Mine uses them.
Yeah. I was like,
and we welcome everybody. Ms. Murphy, would it be appropriate to take a roll call?
Yes, Chair.
Thank you.
Commissioner Egger? Here. Commissioner Benton?
Here.
Commissioner Hawkins?
Here.
Commissioner Holton? I believe Commissioner Holton was planning on participating by phone, so whenever he checks in, we'll note that he's here.
Very good.
Commissioner Jolly?
Here.
Commissioner Pierce?
Here.
Commissioner Randall?
Here.
Chair Spielman?
Here.
Commissioner Wolk?
Here.
Great, thanks.
Very good. Thank you. Well, we obviously have a quorum. We have, in fact, we have almost the entire commission. We're expecting Commissioner Holton to join us shortly via telephone. Thank you, ladies and gentlemen who have joined us today. There are paper copies of the agenda near the back door. For those of you elsewhere, they are online on our website. Bless you. Our next proposed agenda item is approval of the minutes. I'd entertain a motion.
So moved.
Thank you, Commissioners. We have a motion and a second. Any discussion? Minutes from our prior meeting. We have a motion and a second to approve. All in favor, please say aye.
Aye.
Opposed, same sign. Hearing none, those are approved and will be entered into the record. Thank you. Commissioners, we don't have it on the agenda, but let me ask, does the agenda seem appropriate, or would anybody offer an opportunity to discuss or make any additions, Commissioners? Hearing none, let's continue on. Thank you. Our next agenda item is a report from the Executive Director's Office. Commissioner Randall.
Thank you, Mr. Chair. Good morning, Chairman Spielman, Commissioners. Great to see you all. Happy New Year. Hope everyone is doing well and feeling well. It seems like there's a fair amount of crud going around, so I'm glad everybody was able to make it. I'm going to cover a couple of sort of administrative things and then a couple of policy things for you guys this morning. First, I just want to give an update on some staffing and some staffing changes in the Executive Director's Office. We started the new year on January 3rd with 2 new members of the Executive Director's Office, and they're not here, but I want to introduce them to you in absentia. One is a new legislative liaison. Doug Vilsack started on January 3rd. Some of you may know Doug from his time at Davis Graham & Stubbs. He spent 5 years as an attorney at DGS. For the last 3 years, he's been running place called the Posner Center for International Development up in North Denver. He's the executive director there, and he joined us as our liaison on January 3rd, is already very busy and deeply immersed in the goings-on over at the Capitol and at our office, so he's been a great addition. Also, at the beginning of the month, we brought on a new staff member in a new position. This is the Chief Operating and Performance Officer position, and I hired Tobin Fullenwider for that role. Tobin spent the last 12 years at the State Land Board. He was CFO and Deputy Director there, and I created this new position out of existing FTE to recognize the importance of our operations, both for our customers internal through HR and procurement and accounting, as well as our external customers, and to really focus on the performance management and performance metrics priorities of the administration. So anyway, pleased to have him on board. He's already making my life easier, and I couldn't be happier to have him. So we were fully staffed for all of about a week when some changes took place. Our HR director, Tina Miller, was poached by the Department of Personnel and Administration to go over and run be the HR specialist for a new statewide human resources information system. So we're really pleased and proud of her for being tapped for this major role that will now have statewide impact, and thank her for all of her service at the department. And then, as you all probably know, Kathleen Stacks left about a week ago to go over and be the executive director of the Colorado Energy Office. That was a vacancy occasioned by Jeff Ackerman's appointment to be the chair of the Public Utilities Commission. So we're, again, very, very thankful to Kathleen for all of her service to the department. That's a position that we've now advertised and are looking to fill in the next, hope to have somebody in place in the next month or so. Anyway, and then finally, just one more to get it on the record, and in case people who might be listening are interested, our state engineer is leaving at the end of the fiscal year. That's Dick Wolf. He's been in that role for 10 years. We'll be working through filling that position over the coming months. We hope to have some overlap there too. So anyway, just some changes in the executive director's office and within the department I wanted you all to be aware of. I'll touch quickly on the department's legislative agenda. Again, happy to take questions online or offline about any of these things, but just so that you all are aware. So here we are 2 weeks into the session. We've already had 2 major hearings at the General Assembly. We had our Joint Budget Committee hearing on December 15th, and we had our SMART Act hearing where we report on our operations and performance on January 10th. To run a handful of department bills this year. So 2 of them are kind of annual bills, the water projects bill, that is the contents of which are voted on and moved forward by the Water Conservation Board. This year's bill will, we are proposing that it include money to fund the Colorado Water Plan implementation, as well as stream restoration, backfill the Water Supply Reserve Fund, which is not getting any new revenue this year because of declines in severance tax. So that's the projects bill. We'll also run the Species Conservation Trust Fund bill. Again, annual funding bills. A few others that we're looking at. One comes out of conversations that have occurred at this commission, as well as conversations between our staff and Director Lepore and his staff with a group called the Distressed Operators Group. But that's a bill to really shore up the commission's authority to go in and plug and reclaim orphaned wells. Now, these are sites for which there's no solvent operator or an operator that can't comply. And we want to clarify the commission's authority to go in and plug and reclaim and safeguard those sites. And Matt maybe can give some more details on that or not. If again, happy to talk about it. It hasn't yet been introduced. And similarly, on the waterfront, we're looking at a bill to make available statewide the possibility of an agreed upon model for lease fallowing. So this is a goal to allow the litigants before, the parties before water court to agree on a model and not have to fight it out with engineers and save time and cost in doing so. This is there's a presumptive model in the Arkansas Basin. We're looking to make that a tool available statewide. And then finally, at Parks and Wildlife, we're looking to address an ongoing revenue shortfall issue. Resident hunting and fishing license fees have to be raised legislatively. And that's something, those are conversations we've been having for about the last year. They were last raised in 2005. There's no cost, there's no CPI index, or there's no cost of living adjustment. And so our purchasing power is down about 25% of what it was in 2005, in addition to having significant new costs as to things like, believe it or not, fish food is a major cost driver for our hatcheries, water rights, land conservation, and things like that. So they've held 18 meetings around the state. Again, I think I've probably talked to you at least once about this, but again, just heads up that Parks and Wildlife is looking at a revenue bill that would address resident hunting and fishing license fees, boat registration to fund aquatic nuisance species inspections and decontamination, and other matters. So again, looking at a revenue bill at Parks and Wildlife. So that's sort of it on the administrative stuff. I'll touch on a few policy matters. Number one, in December and into early January, there were feverish talks on the Colorado River. There was hope for, so within DNR, the Water Conservation Board is the state's representative on the Upper Colorado River Commission. And there was hope for a drought contingency plan for shortage sharing between upper basin states and lower basin states. And there was a possibility of a minute, which is a treaty amendment with Mexico that would again address shortages and recovery of stored water at Lake Mead in a way that didn't damage Lake Powell, because Lake Powell is our insurance policy against any calls by the lower basin on the river. So there was an effort to get all of this done before the administration changed, just because of the amount of sort of administrative knowledge and inertia in that direction. And it didn't come to pass. Those things would have required congressional approval. And again, there just wasn't time to get that done. Let's see, what else should I touch on? I'm going to talk for a second about severance tax. In December, the governor's budget letter proposed transferring about $32 million of severance tax to the general fund. These are out of funds that have been held by Senate Bill 218 last year, which was a hedge against refunds under the BP decision and other refunds. While the December 20th forecast for severance tax was higher, for severance tax, it was lower for general fund. And so on January 3rd, the governor's office submitted a budget balancing letter to the JBC that proposed a further transfer of $47 million of severance tax to the general fund. I trust you all might have seen the article in the Denver Post over the weekend about severance tax. I thought that was a great article. In fact, I thought it shed a lot of light on some of the challenges that we see. Again, these transfers out of severance tax, I just want to maybe clarify one thing that the article didn't totally make clear. These are transfers out of money that was held under Senate Bill 218. So the general fund under 218 is looking to cover severance tax refunds to the tune of about $110 million. And that's just by function of that bill. And so the transfers, our view is that we're still better off with these transfers. We might prefer that they didn't occur, but we're better off than we would have been had the refunds under the BP decision and ad valorem, higher than normal ad valorem offsets and some of the other refunds. We're better off than without that. So again, happy to take questions on that or talk about it offline. I just didn't want the commissioners to be surprised by any of that. Final thing I want to touch on is another thing that's made the media in the last few days, and that's an exchange of correspondence between Boulder County and the Attorney General. Last week, midweek, the Attorney General Kaufman sent Boulder County a letter pointing out the fact that its moratorium on February 3rd will have run for 5 years, which is the period of time that the Fort Collins case struck down by the Supreme Court in May of last year. On Friday, Boulder County responded. Again, I think Director Lepore might have circulated at least links to those letters, if not the letters themselves. So I just wanted to address those quickly and say, that we were consulted about the possibility of that letter from the AG. We didn't see it before it was sent, but we certainly understand the importance of this matter. The Attorney General is saying there's a violation of law, and that's probably true. But right now there's no lawsuit. I just wanted to clarify that nothing's been filed. We do have our own concerns, and we're continuing to work through those. And just feel like while local governments do have the authority to adopt and develop appropriate regulations under Colorado law, they have to honor property rights and property right owners' ability to responsibly develop those resources. So again, I just didn't want there to be any question that we were, sort of the level of the administration's involvement in that. It's certainly something that we're aware of and tracking closely. So with that, Mr. Chair, happy to take questions on that or any other matter.
Excuse me. Thank you. Questions for the Executive Director? Great report. Thank you. Lots going on. Thank you for keeping us up to date.
Yep.
Thank you. Our next agenda item is a report from Director Lepore. And we have a staff report available, and I believe there were hard copies on the back table as well as posted on the internet in advance. Director?
Thank you, Mr. Chairman. Good morning, everybody.
Good morning.
Happy 2017. I will keep my report very short this morning. I'm going to bend everybody's ear here in a little while on another substantive matter. I want to acknowledge the loss to our agency of Kathleen Stacks. That happened suddenly, and it was like she was here one day and gone the next, but we found Kathleen to be a tremendous partner and help with us in her role as our liaison to the Executive Director's office. So I just want to acknowledge that we miss her and look forward to a competent replacement in the near future. I will say just a little bit more about the legislation that we are proposing through DNR related to the orphaned wells. To put it in context, I think is all I want to do. Back in 2014, the legislature increased our authority, the Commission's authority to impose certain penalties for violations of our rules. And it also increased our authority to revoke an operator's Form 1 and Form 10, that is ability to sell product and also to be licensed or registered in the state as an operator. In exercising those authorities, we hope very judiciously, we have realized that we find ourselves in a place with lots of uncertainty and legally gray areas about an operator who is no longer privileged to operate in the state, but that might have continuing valid leases, that has equipment on location, that might have hydrocarbons in storage on location. And the act and the rules are not particularly clear about the commission's rights and authorities as it relates to things like abandoned equipment, abandoned product, other lien holders' potential rights to the revenue that might be generated by the sale of those things. What happens with leases? Do we have to determine the terms of every lease in terms of when that lease expires as a result of lack of production, for example? How do we transfer either the assets, the wells? Do we transfer the lease to a willing, able buyer? You all know that the commission isn't really set up to operate oil and gas wells. And so often the preferred outcome from our point of view is that another operator step in and take over those assets. But again, there's a fair amount of uncertainty about the status of those assets, the statuses of the underlying leases as we move forward. So that's a lot in a few sentences, but those are some of the issues we're grappling with. We are looking to other states for guidance in terms of, as an example, I'll just, Assistant Attorney General Britta Beckstead has done a lot of research on this and helped us with this issue. Many states have lien statutes that under certain circumstances give the Oil and Gas Commission in that state a superior lien under certain circumstances. That is a tool, a statutory tool that might make some of these things more clear in terms of what happens if sort of scenarios. So that's kind of what we're grappling with. We have recently provided a little bit of a written summary of that. Is available now for Doug Vilsack as he talks with legislators. And I have probably been remiss in not providing that to you. So as I am speaking, I will get that sort of summary out to the commissioners for your benefit. Quickly highlighting some topics in the staff report, the second article there is about our flow line team. I just want to remind you that we do have a dedicated team of 3 staff members operating under engineering manager Stuart Ellsworth and supervisor Mark Schlegenhoff, focused on flow lines because when we analyzed oil and gas incidents that lead to not good environmental outcomes, flow lines and production equipment were sort of at the top of that list. So we've dedicated some staff to that now for about the last year and a half. We continue to generate guidance documents in hopes of shedding light on staff and COGCC interpretation of some of our rules. The most recent one related to reclamation, interim reclamation, where there have been delayed operations. Denise Arthur, our reclamation supervisor, has been traveling around the state putting on a seminar, about a half-day seminar, all about reclamation for the benefit of the operators. Again, reclamation is something that from a staff effort, manpower, time aspect, we have greatly increased that time effort of staff over the last couple of years. And these outreach meetings have been intended for the benefit of operators so they understand kind of our take on reclamation issues. On page 7 of the staff report, in the right-hand column, there is a bullet that says interested parties notification. This goes right back to the orphan and abandoned wells issues that we've been talking about. So just imagine a location or a field with several locations that an operator has abandoned. There's equipment there. There may be hydrocarbons stored there. We want to secure that site. We want to minimize risks to the environment. And so perhaps we want to sell the hydrocarbons or have them hauled away, and somebody will give us money to haul them away. There are royalty owners. There may be tax lien holders. There may be mechanic lien holders. How do we understand who they are and what priority they're in, and who gets that money. One of the steps that the assistant attorney generals have devised to help us with that is this notification. And so we publish that notification and try to sort of proactively find potential interested parties with a claim at that site. On page 8, we have highlighted our Form 27 e-form release. This is Form 27 is our follow-on remediation report. Not follow-on, it is the remediation report, the work plan. Getting that into our e-form system has been a big project that Environmental Manager Greg Duranlo has been leading, and we finally got that out, and I think in beta testing with a group of operators. I haven't had a chance to sift through the statistics for the end of the year, and I apologize for that. I will share this one statistic with you, and that relates to oil production. We're always reluctant to predict oil production at this time of year when people want us to, because our production reporting lags, and we really sort of aim for tax day, April 15th, to have a kind of final report. I will tell you with some confidence that 2016 will be the second highest year of oil production in the state's history, behind 2015, somewhere in the range of 115 million barrels, down about 8%. Maybe these are all guesstimates, please understand that. But still, I think it's noteworthy that, you know, we're all aware of the price downturn, the rig count downturn, the new well start downturn, but production has remained very strong through 2016, which is a blessing, needless to say, when it comes to the issues that Executive Director Randall was speaking of with respect to severance tax and so forth. So there's a bright spot in what has also been a somewhat difficult year. So I think I'll stop there, Mr. Chairman, and happy to entertain questions.
Thank you.
Mr. Chairman, may I?
Please, Commissioner Pierce.
Director Lepore, I want to direct your attention, please, to page 2 of your report and the brief discussion of the LGL situation. Is your expectation that we will fill the position that Ms. Prince previously held, or is the expectation that Mark Morton will be the only?
Thank you, Commissioner. You know, I think there's a great tradition of doubling someone's work and holding them at the same salary. So the short answer is I don't know. The longer answer is I think you and all of the commissioners know we have not backfilled a vacancy at the staff level for more than a year. We are doing that deliberately to help manage our cost structure as it relates to the funding that is available to us, which is diminished. And we are looking, as I've spoken to you in the past, potentially at a very large shortfall in that funding at the 2017-2018 fiscal year. So we haven't made formal plans. That is obviously an important position from our point of view. There's a lot going on in the Front Range, and there's a lot going on with local governments, and those relationships are important. We lost a deputy director. We are holding open positions in permitting, in hearings, in virtually every group. And it's hard to know how to best allocate the resources.
Thank you, sir. Thank you, Mr. Chairman.
Of course, Commissioner. Other Commissioner questions for the Director? I'd like to use this occasion to remind everyone to silence their cell phones, please. Thank you very much. It happens.
It's a nice ring.
Old school. Sorry you had to hear it. No, very good. Thank you. Thank you, Director. Great report. Commissioner questions on any topic in addition to the Director's report or the Executive Director's report? Commissioner Benton? You looked like you were preparing something.
I'm saving them for later.
Very good. Okay, Commissioners, thank you. Let's turn it over for audience comments, please. And this is a portion of the agenda. We invite folks to address the Commission on, frankly, anything of interest on your mind other than agenda items forthcoming where we'll have public comment as well. So we'll turn it over to Hearings Manager Murphy. Run us through this process?
I don't have any.
Well, that might be a first. Let me just ask members of the public, if you didn't have occasion to sign in the sign-in sheet, are there folks here who do wish to comment or make or address the commission? Okay. Well, again, we'll have occasions in future further agenda items for public comment. That puts us significantly ahead of schedule. Another first. Let's turn our attention, commissioners, to the consent agenda. And Ms. Murphy, if you would walk us through it, please.
Yes, sir. As of now, I don't have any changes. And so I would entertain a motion to take up, or I on behalf of the chair, of course.
Well, let's, before we do, let's ask if there are disclosures or recusals. I myself have one. I would like to ask commissioners that with regard to Group F, like Foxtrot, docket number 161000414. I will not vote on that application and would suggest perhaps we pull it out so that the remainder of Group F could be voted on in consent agenda item. And then the commissioners, without my participation, could revisit docket 161000414. Hearing no objection. Thank you. Ms. Murphy?
Are there any other recusals? I jumped the gun earlier. Excellent.
Mr. Chairman, then if I may.
Please, Commissioner Benton.
So I would move approval of the consent agenda groups A through Q with the exclusion of Group F. I believe the docket number you said was 161000414.
414, correct.
414.
Thank you.
So all except that one, to exclude that one so that all the commissioners may vote on the balance.
Thank you, Commissioner Benton. Is there a second?
Second.
Thank you, Commissioner Pierce. Questions or comments? Hearing none, we'll call the question. All in favor, please say aye.
Aye.
Opposed, nay. The ayes have it. Thank you. The record will reflect that there was no vote on docket number 161000414. Ms. Murphy?
Is there a motion for 414?
Mr. Chairman, if I may,
Please.
I would move approval of docket number 161000414.
Thank you, Commissioner Pierce. Is there a second?
Second.
Thank you, Commissioner. Questions or comments? Hearing none, without my participation, all in favor, please say aye.
Aye.
Opposed, nay. The ayes have it, and that will pass as well. Docket 161000414, which should take care of all items in the consent agenda, leading us to the enforcement group A.
So, Mr. Chairman, I would move approval of enforcement group A.
Thank you, Commissioner Benton. Is there a second?
Second.
Commissioner Hawkins, Commissioner Wolk, thank you both.
Arm wrestle.
Discussion? Hearing none, let's call the question. This will be, the motion is to approve all items in enforcement group A. All those in favor, please say aye.
Aye.
Opposed? Nay. The ayes have it. Enforcement Group A and its 10 matters are approved. Enforcement Group B,
Mr. Chairman,
please.
before we entertain a motion, I would like to recuse myself from enforcement group B, please.
Thank you, Commissioner Benton. Duly noted. Commissioner Benton will not participate in docket number 161200307. Commissioners, other recusals or disclosures? If not, we'd entertain a motion, please.
Mr. Chairman,
Please.
if I may
Commissioner Pierce.
move the approval of the single item remaining in enforcement group B, which is docket number 161200307.
Thank you, Commissioner Pierce. Is there a second?
Second.
Commissioner Jolly, thank you. We have a motion and a second. Any comments or questions or discussion? Hearing none, we'll call the question. All in favor of the motion on the table, please say aye. Aye. Opposed, nay. The ayes have it. And Enforcement Group B is approved without the participation of Commissioner Benton, for the record. Thank you, Commissioners. Let's continue on, shall we? Next agenda item, staff presentation on Rule 318A by Director Lepore.
Thank you, Mr. Chairman. I know that Commissioner Holton was very interested in this topic, and I am not sure he has yet joined us. Commissioner Holton, if you're there, say so, please. And if not, would it be okay to take a break and see if we can fix any technical issues that might be interfering here?
I think that sounds very appropriate. A great idea.
Thank you, Mr. Chairman.
Without objection, Commissioners? Let's do that. Thank you. We'll take 5 minutes and see if we can add Commissioner Holton to the discussion. Thank you. Perfect. We're glad you are. Thank you for making this work. Commissioner Walk stepped out for just a moment, but I believe since he has the PowerPoint, we could get started. Keep us on. Director, at your ready.
Thank you, Mr. Chairman. We have been talking about and thinking about how Rule 318A works for several months now, and we have spoken to the Commission on this subject in the past. Perhaps 2 hearings ago, the Commission asked us to prepare a white paper, I think was the phraseology used, to lay out these issues. We might have fallen a little bit short of white paper, but we do have what I hope is an informative presentation that we'll make available to all of you and that I will present to you today. I first want to thank the staff members that have worked on this with me. Julie Murphy, our hearings manager, Jane Stanzik, our permitting and informational services manager, and also David Beckstrom, one of our enforcement officers, have all worked very hard to pull together the information that we're going to present to you today. The first thing I want to do is point out to you that in the title slide here, we've really changed the topic, the subject of the presentation, because as we dug into this, it became clear to us that it's not only or just a 318A issue. What we're really grappling with are spacing unit applications or spacing applications from different operators who are in conflict, the applications are in conflict. And those arise under both 318A and our traditional drilling and spacing unit scenarios. So we've sort of expanded the scope and acknowledged that this is not solely a 318A issue. In a 2 or 3 sentence synopsis of what we're grappling with, it's this. We get application A for some kind of spacing unit, whether it's a wellbore spacing unit or a traditional spacing unit, and it satisfies our rules. It has the appropriate setbacks. It has mineral ownership. It is a drilling and spacing unit that is consistent with other drilling and spacing units that you have approved in the past in the greater Wattenberg area for shale development, or it's a wellbore spacing unit that meets the requirements of a wellbore spacing unit. Hot on the heels of that application, we get a second application, or we get a protest of the first application, followed by a second application seeking to space partially the same lands and partially some other lands. It also meets all of our rules. It's a perfectly valid legal application that, but for the earlier filed one, we would move ahead with approving. Here's the question. How do we staff or you commission choose between those 2 competing applications? And the simple fact is there are virtually no criteria. That might be a slight exaggeration, but there are very limited criteria for either the staff or the commission to evaluate in picking between those 2 spacing applications. The spacing applications have to demonstrate that they would protect correlative rights, not lead to waste. Those are 2 essential criteria. They have to be not smaller than the area that is anticipated to be drained by the well, which goes to correlative rights as well. We have setbacks they have to qualify for. Those aren't that hard to meet. So again, most of the applications meet those criteria. So it's after that, what do we look at? Historically, staff has looked at first in time. Pretty simple. First one in the door. And we've done that for a long time. And a lot of applications for spacing have been approved because they were the first one in the door. I'm going to show you some of the conflicting, competing applications that you've ruled on in the last year or so. And in almost, I think, every case, the staff recommendation was the first filed. So I think the issue is that's not very satisfying, or that we feel that maybe there are nuances and complexities that tiebreaker, I call breaker of first in time, doesn't. And when we get these competing applications, you hear usually from the protestant, the proponent of the second filed application, you hear various ways in which they would assert the application meets the intent or purposes of the Oil and Gas Conservation Act better than the first filed application. And that they sort of have that burden to carry. But again, the things that they're talking about tend not to be in the rules or regulations. And I should point out that first in time is not in the act. It's not in the regulations. There is no formal written policy that I could hold up and show an operator and say, sorry, you were second, we're going to approve the first one. So that's my opening statement, and then I'll kind of dive into some of the details here with the slides. So to remind everyone, we are going to start with 318A, which creates an opportunity for something called a wellbore spacing unit in the GWA. I have to point out that this is limited to the GWA, and most of our focus has been on GWA spacing applications, not exclusively, but primarily. Wellbore spacing unit for a horizontal lateral is made up of the quarter sections through which that wellbore will pass, and any quarter section that is less than 460 feet from the path of the planned horizontal wellbore. And I'll show you a picture here in a second that makes that a little bit easier to visualize and see. And an interesting feature of wellbore spacing units is that they can overlap one another, and very frequently do. The other interesting feature about wellbore spacing units under 318A is that they were set up to be approved under a somewhat expedited administrative process. So a proponent of a wellbore spacing unit actually does not file a wellbore spacing unit application with us. They provide notice to the other mineral interest owners, working interest owners, or unleased mineral interest owners in any lands through which the wellbore will pass. Those owners have 30 days to object to the wellbore spacing unit proposed on very limited grounds, and the grounds are highlighted in the green text. They can object on the basis of waste, harm to correlative rights, or the fact that the applicant does not own the minerals through which the wellbore will pass. Not uncommon to see all three of those things raised, but typically the thing that gets, that throws the red flag onto the field for review is the fact that the opposer, the protester, owns some of those minerals and has their own ideas about how they want to develop those minerals. So if there is no objection in that 30 days, then the wellbore spacing unit is approved. Essentially, the applicant files an APD, and when we approve the APD, it's all done. So there's efficiency in that process, and that efficiency is something that the operators value. And it is something that tilts them towards wellbore spacing units in favor of wellbore spacing units as opposed to drilling and spacing units, the traditional 34, 60, 116 drilling and spacing units. So absent the objection, we approve that wellbore spacing unit. If there is an objection, then the first response is operators go work this out amongst yourselves. If that doesn't happen, the applicant may request a hearing in front of the commission to resolve the issues, and the opponent has the burden of proof in that hearing. Well, that wasn't a very good thing to do. Okay. So we're now on track towards a commission hearing, and I just wanted to say that what that really means is that staff spends a lot of time with the two operators going back and forth about whether the objection is valid and what it was based on, and having a pre-hearing conference and sorting through all of those issues before we get to a hearing in front of you. So again, just to illustrate the wellbore spacing units, in this case, we have a laydown proposed horizontal well that is going to pass through the north half of that section for 2 miles. So it goes through 8 quarter sections, and you get, 8 quarter sections. Quarter sections, thank you. 8 quarter sections, and you get a 320 acre wellbore spacing unit. If that were a 1 mile lateral, you would have 4 quarter sections. You potentially have a 160 acre unit. It could also be, and this is a little complicated, but if you look at the green line passing through the middle of that green rectangle, you see how that same 2 mile lateral could be part of a 640 acre unit because it's located in the middle. It picks up all the quarters on both sides. So instead of 1 row of 8, you get 2 rows of 8 quarter sections. And then likely you would have 2 other wells, one like the original purple line that we showed, and the second in that south half of the north half, going through those 8. So you've got 3 wells in there. You've got 3 separate wellbore spacing units. Okay, that's how wellbore spacing units work. The alternative to that would be somebody could ask for the 640, which is be the north half of both of those sections. That'd be a 640 acre drilling and spacing unit into which they could place however many wells they thought it was appropriate to drain that acreage. Does that make sense to everybody reasonably well? Okay, and then just so we see the other side of the coin, the traditional drilling and spacing unit is established pursuant to section 3460(116) of the Oil and Gas Conservation Act, which gives the commission authority to create drilling units and pool the minerals within those drilling units. We're not going to talk about pooling today. And here's the criteria: to prevent or to assist in preventing waste, to avoid the drilling of unnecessary wells, or to protect correlative rights. So that should sound pretty familiar. So essentially the same things that wellbore spacing units are intended to do. And then we do it here. You have the power to establish drilling units of specified and approximately uniform size and shape covering any pool. We could spend a lot of time talking about what approximately means as far as the size and shape goes. You all know that you have approved horizontal drilling units. Well, we're going to show you some statistics, but suffice it to say that anything from 160 acres to over 3,000 acres for horizontal development of unconventional shale has been approved by the commission. So I tried channeling Commissioner Craig and said, let's identify the problem first. And here's my best effort. And I'm sorry it takes as many slides as it does. But we are seeing this increase in the percentage of contested spacing applications. And we don't really have stats on that. I apologize. We all will tell you that it's increased from what it was a couple of years ago. Again, most of the time, those end up being resolved between the operators before it ever gets to you and before we invest a great deal of time in it. But that said, as I mentioned earlier, as soon as there is that protest, it kind of ratchets up the time that our hearing staff is going to spend on that. If they don't get resolved, and you've seen these, and I'm going to revisit them with you, then it comes before you, a lot more time involved by you, by staff, by the operators, et cetera. I've kind of touched on this already. These applications invariably meet our basic requirements. Absent the conflict, either one of them could be approved. The unnecessary wells one, as I thought about it, I think is maybe interesting. I don't find unnecessary wells. I think the market takes care of that for the most part. I think operators decide how many wells are appropriate in a given spacing application. So now we will talk about, obviously, if you could put a 2 mile lateral in place of 2 1 mile laterals, you're reducing the total number of wells. I'm not sure that makes either of those 2 1 mile laterals, quote unquote, unnecessary. And again, the drilling unit sizes that have been approved by the commission, are they approximately uniform? I suppose I could make the case. They vary pretty significantly. One of the things that we've talked with you, and we'll come back to it today, is, should you could consider a default spacing unit size, or perhaps a minimum spacing unit size. And we'll talk about that, but I think that's, that gets to that uniformity of drilling unit sizes. So faced with these competing applications, what have we done? We have used first in time as the tiebreaker. And as I've already told you, while we could probably trace that history back decades, I can't point you to a statutory or regulatory basis for that. It's just been the commission's practice. So as I mentioned, then when we have these protests, it's usually the objector, not always. Both parties are going to tell you why their plan is better. But here are some of the arguments that we've heard. Wellbore orientation. Operator A has plans to go lay down east-west. Operator B wants to go north-south. And they're both going to come tell you that their plan is better incrementally by some margin of estimated ultimate recovery. And they'll probably argue that therefore theirs prevents waste. Alternatively, one side or the other might argue that if the one operator goes lay down, they won't be able to go lay down for one reason or the other, and that will harm, or they might even argue that going lay down is inefficient from their point of view and therefore would harm their correlative rights. We have heard wellbore length. Very recently, I think this will, I'll show you this example. I think it will be very familiar to you. Longer laterals potentially could reduce the total number of wells. Operators will argue probably that there's a better return on the investment for the longer lateral. It does perhaps make intuitive sense. You are going to drill one longer well as opposed to two shorter wells. There's less capital expenditure. Longer laterals have potential to reduce the total surface disturbance. Probably a good thing, I think. Broadly speaking, in most of our minds, we'd like to minimize surface disturbance. Sorry to tell you, I don't think that's in the statute as far as the criteria for creating spacing units. Planned use of pipelines to reduce truck traffic. Great idea. Like it, not in the statute, not in our rules. Other things we've heard. One operator has a small acreage position in a particular area, small, relatively small, maybe it's 320 acres. Other operator has lots of acreage around that and has grand designs for how to develop that acreage. Sort of integrated truck traffic routes, integrated production facilities, centralized production facilities, pipelines perhaps to pipe oil off rather than truck it. All sounds good. Really like that a plan. Have no basis in the statute to lean that direction. And I may be exaggerating a tiny bit. You can probably find, protection of public health, safety, welfare, and the environment arguments to make about that. Commissioner?
Sorry to interrupt. The question I had is when you mentioned that master development, it does tie that, do we not have something about a comprehensive development plan? And would that be somewhat similar to this in your mind?
Thank you, Commissioner. We do, and I'll sort of circle back to that. But yes, well, there is Rule 216, which contemplates comprehensive development plans. We also have something called a geographic area plan in the rules. And I will pose to you a little bit later on that those things might be criteria that you would like to consider or like the staff to consider. And also tell you that in the applications that have been presented to us thus far, in play, that the operator had not engaged in the comprehensive development plan or a geographic area plan. They simply came here and asserted to you that that was their intent. Yeah, I think that's a significant distinction. Timing of development is another issue. So the applicant says, hey, I filed this because I'm going to file APDs as soon as you approve this, and we're going to be breaking ground in a few months. Operator B says, well, we have sort of a grander design and it's going to take a little bit longer, but nonetheless, we don't want our grand design interfered with, or we're going to do 2 mile laterals, they're going to do 1 mile laterals. 2 mile laterals are better than 1. We should win. Dilution of mineral interest within the proposed unit, and this gets sort of back to, hey, you know, sorry, I've only got 320 acres, but I've got 320 acres and I want to develop them. Or the other operator has 160 acres, we have the other 480, and the 160 acre wants to develop them and dilute my 480, or sort of abscond with my 480. So why are we here? We are here because we would like your direction. We would like input from you on, are there other factors as we evaluate these competing applications? Are there other factors that you would like to receive information on from the respective applicants when they come to you? And if there are, trust me, we will get that information and we will work through those issues before they get to you. Because again, right now what's happening is we are largely deciding on first in time and then presenting these to you, and you ask lots of difficult probing questions, most of which we've asked, but most of which don't help us get to an answer because they're not recognized criteria.
Director?
Yes, sir.
Excuse me. Does that presuppose they only come to us, if you will, if there's been a statement of opposition? Remember you told us a few slides back, the non-opposed ones would be handled at the staff level.
Correct. Right. So non-opposed,
We don't see it.
nothing changes. Right. Opposed, we would start down this path. We would say, again, this is so critical that we want to know. I'm going to throw out one example. If the respective applicants' percentage of mineral ownership within each of their proposed units mattered to you, was something you thought should be considered deciding for A versus B, then we would be sure we had that information and we would have the conversation with the operators. If you favor 2 mile laterals over 1 mile laterals, we would have that conversation.
Thank you.
I think the third bullet there is important. I don't know that we are clearly not asking you for a rulemaking now. And that means, from my view of the world, that we are then sort of relying on voluntary compliance, if you will, from operators when we say, well, what's your mineral interest ownership? Or when we say, tell us why 2 miles is better than 1 mile. I mean, we're going to know what they're proposing, whether it's 2 miles or 1 mile. But, you know, what does that get you? If they say we're going to use pipelines, then we have a lot of good questions. When? How do we know? When will we know? So there's this aspect of, you know, we're doing this on, you know, voluntary basis, a good faith basis. If you don't tell us, you're going to lose. I mean, I don't know how that goes, but, you know, obviously without rulemaking, that's where we are. All right, so let me, hopefully with some expedience, go through some of these competing application scenarios, all of which you have seen. I can do it relatively quickly. And I probably need to get to my notes at this point. There's the trick. Okay. The applicant, the original applicant in this case, sought this 640 acre spacing unit with the intent to drill stand-up 1 mile laterals. We don't know exactly the applicant's mineral percentage ownership, but it was not more than 75%. So in other words, we know somebody else owned a quarter of that section. The protestant came along and wanted to do, I'm just going to jump up to here. The protestant owned that mineral acreage and proposed the 1280 for both sections. They protested the 640 and they proposed that 1280, and they wanted to go stand-ups from north to south. So again, just looking, the protestant had 320 and 160. They had 480 acres in their proposed 1280, less than 50%. The applicant were uncertain of. They might have owned 75%. They might not have. We don't know. The protestant argued that 2 mile laterals are better than 1. Efficiencies, fewer wells necessary to be drilled, etc. Staff recommended approval of the original applicant 640. Why? First and time. And the commission voted 4-3 to support that recommendation. In this case, the applicant held the northeast quarter. They applied for that 320. They were going to go from, let me back up. They were going to drill from the west quarter section, so off their lease, and they were going to do lay down laterals into and develop the acreage in the north half. The blue acreage shows the protestant's leasehold. So the protestant had lots of acreage surrounding that northwest quarter of section 12. Again, some of the protestant's leasehold acreage. The protestant came in and said they would like to develop that whole 640. This was one of those where the protestant said, we have plans for that entire area. We can make this more efficient. We can have these centralized production facilities. We're going to put pipelines in, and that, you know, letting somebody who owned that quarter section develop the half section was sort of diluting their opportunities. And they just didn't want to see that happen. Staff recommended approval of the original applicant's 320, and that's what the commission approved. I hope you remember this one. We still have nightmares about this one. So after lots of sort of jiggering around with wellbore spacing units and whatnot, we start with the point in time at which one of these parties sought a 320 drilling unit for the south half of this acreage for section 2 and proposed to go east-west with 1 mile laterals. The protestant came in and wanted to do a 640. They wanted to go north and south. Interestingly here, the protestant originally was believed to own no acreage in the south half. They later asserted that they had a very small incremental share in that south half. I'm relying on my memory right now. To the best of my knowledge, staff's recommendation was to approve the application for the south half. It came to the commission. The commission told the operators to go away and work it out, and they eventually did do that. So there was not a commission decision on this. At one point in time, the staff said to the operators that the staff's recommendation to the commission, if they didn't work it out, would be to create a 640-acre drilling unit in which the operators would be compelled to be joint operators with equal opportunity to drill wells and share them. And I can tell you that the operators thought that was the worst idea of all time. Okay, and this one is just a composite of many that we see, and it's simply that one operator says, let's do this, and the other operator says, oh no, let's do that. And they've both got mineral ownership in those various sections sufficient to justify that. And we sit here looking at each other, scratching our heads. We'll see a lot. We have more of these in the pipeline right now. So, all right, let's get to the heart of this. What should we be considering as alternative tiebreakers or additional tiebreakers? I mean, I love thinking about, the NFL playoffs. First it's head to head, then it's, I don't know, then it's strength of the, I don't know what those 52 things are that get you, to some point that who gets to go to the playoffs if it's all knotted up. But that's kind of how I think about this. What else, if it's not first in time, by the way, if you want it to be first in time and you want us to keep doing that, I'm fine with that too. Simple, done it a long time. But, as we know from potentially one of the matters that is on the agenda today, the commission often says to the operators the same thing that we said 2 to 4 to 6 months earlier, which is go figure this out. Don't make us be the referee here. But if we're going to be the referee, what do we want to look at? So these are things that we have thought about internally. I have said to you, should we have a default spacing unit? And a default, in my mind, would not be dispositive, but it would be, if you're asking for something different than this, you're probably playing defense. But we've got statistics now, and I can tell you that it doesn't break out terribly clearly. You've approved a lot of 640s, a lot of 1280s, a lot of 320s, and a pretty good number of 160s. If the trend is towards longer laterals, well, that suggests that you wouldn't want the default to be 160 or 320. I'm not sure it suggests much more beyond that. And as I've thought about this, I would say that a minimum is better than a default. The expected minimum is X. And if you're asking for less than X, then you've got some splaining to do. Or, like I said before, you're playing defense if you're in a competing situation. Obviously, the size of the unit is related to the wellbore length. It's not, maybe I shouldn't say that. It's barely clear to us that there is a definitive trend towards longer wellbores. You hear that, you've been told that very recently in one of these situations, how much better 2-mile laterals are. The reality is that 2-mile laterals are a site-specific case-by-case decision by the operator, in my opinion. They're evaluating lots of factors. And a year from now, it might be 3-mile laterals, or it might not, and it might be case-by-case. But, we can look at that. 2-mile, we've talked about it. Fewer wells, fewer surface locations, arguably better return on investment. Lots of things to think about. Do you want us to consider the parties' relative respective mineral ownership interest? If somebody has 10% and the other person has 90%. If somebody has 35%, do you want them to have 51%? Do you want to not say a number, but say, we want to know, we want to evaluate that? And if we are determining their leasehold interest, do we want to know whether they have a JOA with other working interest owners, or whether other working interest owners are at least in support of their application? Commissioner Benton, here's your point. I would love to see some broader spectrum planning and development, fraught with peril. Ownership is so diverse in the GWA. It's certain operators have large holdings in certain parts of the basin. They tend to develop those. They tend to do it in a well thought out way. But nobody has brought a comprehensive drilling plan to us. Nobody has brought a geographic area plan to us. I can say that I know of a couple of circumstances now where operators are working fairly closely with local governments ahead of bringing us applications. So I've added that as a potential third element of this planning aspect. Timing. Again, in one of the examples I showed you, operator applicant was a smaller operator, smaller acreage position, ready to go. Testified to you that the mineral interest owners were ready for them to go, tired of waiting. The other operator said, well, again, we've got big plans, but we're not going to be there for a couple, 3 years. Does that matter? And then what are we going to do about really ascertaining those plans? A preference for oil pipelines versus storage tanks. And again, for me, the bigger question there, yes, I can tell you I would prefer that. I cannot tell you how I determine the reality of the statement that we plan to use pipelines. Great, I plan to be 7'2", but not sure how I'm going to get there. And then lastly, again, internally, we've thought about this a lot over a period of time. We write things down and then I forget them and lose them. So I don't know. I want to make sure, if there are other things on your thoughts, I certainly would like to hear those. I do have a few more slides that are just numbers for you. We've talked about, is there a trend in drilling unit size? Is there a trend in wellbore length? We actually, part of this conversation early on was, it seemed to us initially that more of these conflicts were arising in the 318A arena, the proposed wellbore spacing units. And we actually talked to you and talked to operators about maybe 318A wellbore spacing units have outlived their utility. There's this expedience, there's this, we got to do this quickly. If there aren't objections, and I honestly don't think that everybody thought fully through what happens when there are objections. And so I think we bumped up against that. But here's what the stats tell us. The stats tell us wellbore spacing units are popular. And in a different context, a wellbore spacing unit might be the perfect solution to protecting correlative rights, for example. So I don't think you're going to hear us today say it's time to get rid of 318A wellbore spacing units. But let's just show these statistics and then don't forget to think about the other factors. There we go. Okay. You gotta get used to this for a second, but the red are 1 mile laterals, the greenish are 1.5 mile laterals, the purple are 2 mile laterals. We are looking at 2014, 2015, and 2016. These are well bores that have been drilled and completed. So, not sure there's a trend. 17% 2 mile laterals 2 years ago, 20% today, 22% last in 2015, and it's fairly consistent. The one thing I will say from a statistical point of view is that we only have 138 data points for 2016. We've got quite a bit more for 14 and 15. So maybe as some of those wells that were proposed in 2016 get drilled, we'll see a little clearer what everybody sort of intuits. But it's not gigantic at this point. the real point here, this is a lovely slide if you have some time to dissect it all, but here's the point. The bottom bar are well bore spacing units, okay? The 318A well bore spacing units, there were 3,600 of those between 2014 and 2016. Remember, every well bore spacing unit is one well. 3,600 wells in the ground using a wellbore spacing unit. The top bar are drilling units, 1,549 of those, so a little less. Total wells, I'm sorry, total wells in the drilling units is 1,549. Not units, wells in drilling and spacing units. So wellbore spacing units are popular, sort of 2 to 1, a little bit more than 2 to 1. And all the colors relate to the sizes of those different units. And that somebody can spend a lot of time parsing that out if they want to. So here are the traditional 3460, 116 drilling and spacing units in those 3 years by size. Here you can see the purple are 1280s. So 1280 is a pretty popular size for a traditional drilling and spacing unit over the last couple of years. And that does indicate a change from 2014 when the 640s were almost 50% and the 1280s were closer to 40%. The 1280s have stayed in that 40% category. And you've had sort of a back and forth between 640s, 320s, and some other sizes. This is the cumulative picture. So essentially the same information in a slightly different visual way. This is, again, cumulative of those 3 years. And you can see that the 1280 is 42% of all of them. The 640 is 33% of all of them. And the 320 is 13%. These are now the wellbore spacing units, kind of the same information for wellbore spacing units. Again, I don't know, I'm not a statistician. I guess we can see that greater than 640 acre units have gone up from 13% to 20%. The 480 greater than or equal to 480 is kind of hovering around the same. Greater than or equal to 320. Less than or equal to, I mean less than or equal to. Julie Murphy assures me that I mean less than or equal to. The 320, again, diminishing slightly. Cumulative view of that. All right, that is the last slide. So the statistics for me personally didn't give me, a clear answer. And really, as I think about it and, as we observe what we observe, a lot of those decisions are very situational. I certainly understand the logic of how a single 2-mile lateral has some efficiencies to be gained. But I don't think I would say that we see a clear trend away from 1 mile or even 1.5 mile to 2-mile laterals. We do have some 2.5-mile laterals proposed in applications that are in front of us now. So I'm going to stop there. Happy to try to answer questions. And again, the main purpose and whether that comes today or in the future is to get some guidance from the commission on if there are alternatives or additional tiebreaker factors for us to be evaluating in these competing applications.
So that's where you want to go now. You want input from the commissioners on that question or questions?
Mr. Chairman, yes. I mean, I certainly, whether that's in the form of a dialogue or clear direction, or we're going to think about it and get back to you. I don't have a strong preference, but you know what the status quo is. I can tell you that we have competing applications in the door right now. And I would like to be, well, I'll be very blunt. I had told my colleagues that in one of these competing applications, I intended to ask the operators to very, very clearly identify their mineral ownership in the acreage. And their response to me was, I don't think you want to do that without informing the commission. So
Okay.
There you go.
Well, great. Well, thank you. It's an excellent presentation. Why don't we open it up to commissioners and see what's on folks' minds?
Mr. Chairman, may I?
Please, Commissioner Pierce.
Director Lepore, you had a slide dealing with one of the previous cases in which an operator proposed 2 stand-up wells and what looked, as I recall, the south half of a section. Yeah, the middle row, left-hand side. That was slide, I think, is what I'm talking about. That look right? Yes, thank you. As I recall your description in this case, the first application in the door was for the 2 wells in the southern of the 2 sections.
You are correct, except that it was not necessarily 2 wells. The illustration is just so we understand the orientation proposed. And I do not know how many wells were proposed in that unit. And if staff does, they will tell me, but it's similarly, the graphic shows 2 wells from the north.
Okay.
It probably wasn't 2 wells.
All right. You mentioned at the beginning of your presentation that it is not uncommon, if not common, to have overlapping wellbore spacing units.
Yes, sir.
Help me think about this particular dispute and overlapping spacing units. What happens if you say to both operators, okay, you got your wellbore spacing unit. If we allow overlapping wellbore spacing units, why don't we just say yes to both of them?
Bob, I know that's a question, you're waiting for an answer, but I can see a conflict. Just if the operator that wants to drill from the north, south, wants to drill a 2-mile lateral, and it's not just 1 well, it may be 12 wells or something. And the operator that's on the southern part wants to drill 12 wells, 1-mile laterals, you're gonna end up with 24 wells in the south half with that overlapping spacing units. And that's probably unnecessary.
I want to continue this discussion, Commissioner Hawkins, but I would indicate to you that if commercial aspects of the oil and gas business dictate whether or not wells are drilled, then I would suggest that the commercial aspects of the oil and gas business would sort out the problem which you discuss.
So Commissioner Pierce, my issue here is going to be one of correlative rights. If you have a 640 in section 23 overlain by a 1280 in 14 and 23, then for the 1280, everybody in 14 is sharing revenue with everybody in 23. For the 640, everybody in 23 is keeping all of the revenue and not giving any of it to 14. So somehow, unless I'm thinking of this incorrectly, the folks in 23 are much better off. They're participating in the 1280 and not their benefit. They get the sole benefit of the 640 in 23.
It would, my thought on that is, if we assume, perhaps incorrectly on my part, but if we assume that this is a homogeneous reservoir, then with regard to the royalties, that shouldn't make any difference. Because if you have 1280s, the owners in 23 will get the proportionate share of production from 23 and the proportionate share of production from 14. So it seems to me that, as I say, if you assume a homogeneous reservoir, the math, I don't see how it doesn't work. But perhaps operators would tell us that the operator in 23 and the operator in 14 have different views of reservoir quality.
I agree with your assessment. I think the wells that are drilled 2 miles long are being shared 50-50 between the two sections. And the wells that are only 1 mile long, drilled in the south, are only being shared with the section in the south. So
Yes.
I think correlative rights from that point of view seems reasonably protected. But I also view that if, I guess in each wellbore is a separate spacing unit is what you're saying. So it's being shared appropriately for that wellbore. And if the operator in the north half wants to drill some additional 1 mile laterals just for their section, then they would be protected with that. And the owners in the south half or in the south section are not going to be harmed. So, I mean, maybe that would work. I think what my biggest concern is that it doesn't really lead to a well thought out plan development for this area. I mean, it seems to me that if the commission did say we're going to establish fixed 1,280 acre spacing units or whatever size we determine is appropriate for 640 acre spacing units, that has a starting point that we know that all the owners in that 640 are going to get their fair share. And the operator may not have 100% working interest in it. So there's going to have to be, operating contracts between owners. But it also prevents certain acreages being stranded because they didn't get developed. They're not participating in any production. And that's the things that kind of concern me when I see a lot of wellbore spacing units and then portions of the reservoir undeveloped right beside it that are maybe they're 40s or 80s or something that just nobody's going to put in a short lateral to try to develop that, and it's not going to share in production that's immediately adjacent, and so it becomes stranded. And that's one of the concerns that I have.
If I may, Commissioner Hawkins, I will tell you that that stranding scenario is one in which the staff clearly would invoke the concept of waste and raise very hard questions about how that acreage would be developed if it wasn't included in either the spacing unit or the wellbore spacing unit. And we have a recent example where an application was submitted that would have left out a quarter section, 160 acres, and we're at least at where that stands right now. Staff is not going to recommend approval of that to the commission. So that particular issue is one we're pretty mindful of and would certainly influence our recommendation to you.
Mr. Chairman, may I?
Please, Commissioner Pierce.
I want to assure my fellow commissioners that I think this is a lot to think about. I find the questions very interesting, but not easily answered. So, let me ask you to speculate for a couple of minutes, if I may, Director Lepore. You mentioned several times that the historical practice of staff has been to, perhaps it's fair to say, favor first in time, but that is not written anywhere as anything more formal than that's what we usually do. To the extent that staff is seeking or at least questioning whether or not some assistance from the commission is possible, and you indicate that at this time you are not ready to propose any rulemaking, help me think through, Matt. I mean, if this commission indicates to you formally or informally that we favor first in time, what's the downside to that? And I mention that because I have some historical experience with Wyoming, in which Wyoming went much further out with canonizing first in time. And it caused a good bit of disruption, as I understand it, in Wyoming, in the sense that it caused a flooding of the agency with applications, because now, rather than planning operations, operators acted to make sure they were first in line. So if they came up with a plan later, they would be allowed to do what they wanted to do. And that was a real problem, I think, in Wyoming. And there may be some people in the audience who have more experience at that. But I mean, what can and should this commission do to try to further Colorado process?
Thank you, Mr. Commissioner. I too am somewhat aware of Wyoming's travails, and members of the audience know better than I. So the term I've heard operators use is secure operatorship. So again, operators tend to want to develop their own leaseholds, and if they don't have the lands spaced and such, then they run the risk of not being able to do that. And that is what led to the flood of applications in Wyoming. I think largely there were two operators, each of whom had large acreage positions, and they were nearby or perhaps adjoining, and each wanted to operate their own. Wyoming, I know they threatened, I think they did impose a substantial fee for filing the application as an attempt to cause the operators to slow down and think about it. Were we to go down that path, I think that, and again, I could pick up the phone at the break and probably call Mark Watson in Wyoming and get details, or some of the audience members could probably tell us too. But, I know one of the things that the Wyoming Commission was considering were putting time limits on development of those spaced lands. So, our spacing applications really don't expire. So I think that would probably be the first thing I would think about is fine, this is spaced, and if there's not a well there in X days, weeks, months, then it's no longer spaced.
Mr. Chairman, may I continue? Thank you. The practical effect of how your agency is operating now, is it fair to say that there currently is an informal presumption that first in time is the rule and it is the obligation of a protestant to overcome that implied presumption?
I think that is a very fair characterization, Mr. Commissioner. And in fact, I was invited by a law firm and a gentleman who practiced routinely in front of you to address the Denver Association of Petroleum Landmen within the last couple of months. I shared the stage with Mark Watson of Wyoming, and the title of the presentation was Operatorship, and it was all of these issues. And I think I made clear to that audience that, like it or not, at the end of the day, we're a first in time state too. It's just not, from the operator's point of view, and I'm not sure I understand that, and maybe we're shaking that up today. The operators seem to think that we're considering other factors, and those other factors do get put in front of you. But I would probably turn to Ms. Stanzik for sort of calibration and verification, but the vast majority of the time, if there's not a stranding issue and both applications meet the rules, the one that gets our recommendation is the first filed. And you all came within one vote of deciding a different way very recently. But I think it is understood among operators informally that it's first in time. Do you want to add? Do you agree?
I would agree. But, you know, one thing to consider in the creation of a drilling and spacing unit, it does not have along with it operatorship. Once that unit is created, anyone who has a mineral interest could submit an APD to drill a well in there. So we're a little bit different in that respect. It is kind of implied, you know, if a particular operator spaces the lands, that they're the ones that are going to, but the order itself does not indicate that only that operator can propose and drill wells to develop that unit.
And that raises a question in my mind, if I may. If that scenario comes up, if a drilling unit is created and an operator who did not create the drilling unit files an APD, what happens? What happens if the operator who did create the drilling unit wants an APD? I mean, do we get back exactly where we are, where we're talking about?
Mm-hmm.
Okay.
Yes.
All right.
I'm kind of thinking about that a little bit. I know that the wellbore spacing unit is being created based on our definition of the 40s or the quarters that are going to be drilled through from a proposed well. So you can only envision a drilling a wellbore spacing unit for a specific well that somebody's planning. So it's kind of hard to think that somebody else is going to jump in there and change.
No, for a
where the well's
wellbore,
gonna go,
the
but-
wellbore spacing unit is, like you said, unique to the well, and it is created upon the approval of the APD.
Okay.
The rules provides for administrative creation of the wellbore spacing unit.
All right.
It doesn't say exactly how that happens. It just says the director has the power to do that. So in practice, when we approve the APD, that creates the drilling and spacing unit. The APD is approved. No one else can come in. You're right. But what I was talking about with the drilling and spacing units.
Okay.
Yeah,
I
there's a
understand now.
distinction.
Sorry, Mr. Chairman.
No,
I'm
please.
hogging the thing. I apologize. I
Then
think
we'll go-
I
Then we'll
understand.
go to Commissioner Benton.
Understood you, Director Report, to indicate that in not all of these cases, the record before the commission was not clear about mineral ownership. Did I understand that correctly?
The record on mineral ownership has not been clear in some of them. I didn't look at each of these again closely enough to say we did, we didn't, we did, we didn't. In the one that's on the screen, no, the one that's on the screen, we had a, no, and the one that's on the screen, actually, I don't think we knew. I don't recall that we knew the applicant's ownership in the south in the section 23.
If the commission staff considering this or a similar matter wanted to know the mineral ownership position for the competing application lands, is it empowered to ask for that information?
I think the answer is yes. I know we would ask and we would expect an answer. We'd see what happens.
Yeah.
And then again, I think if we do that, I think we want to know if there is an existing JOA or an existing agreement among other working interest owners in the acreage as well. And then I think there also may or may not be at that given point in time when the application is being filed. But I think that would be sort of part of the calculus.
I think, pardon me, Mr. Chairman, I think I may have less experience with these questions before this commission than some of the others in attendance. But to the extent that you're asking for guidance from the commission today about things that might be included for our consideration, I think that would be a helpful discussion, at least for my consideration of those matters, to talk about all of the interest owners' proportionate share of all of the competing proposals. I'm not sure I want to get us into that, but I'd like to see it. So.
Commissioner Benton.
Thank you.
Thank you, Commissioner Pierce.
And thanks, Commissioner Pierce. So as an operator in Colorado and Wyoming, we did get to participate in the Wyoming First in Time. Some of the reasons that we did that was for issues around who may be the operator, but a lot was tied in that particular case as to efficient development of a fairly large acreage block and being able to space that. Part of it was tied to things related to sage grouse mitigation. So there was an effort to, let's put this together. We were somewhat less interested in that we had to operate everything in that particular case. We were willing to in cases where we had a smaller working interest or mineral interest than some of the other competing operators who actually initially proposed it. We said, we're fine if you want to operate these. What we're looking for is what we believe at this time with the information we have, what is the most efficient way to develop this area? But nevertheless, we were first there and we hustled to get that in. So thinking about that, I think that First in Time does have some value in being able to do that. But tied to that is also what Commissioner Pierce said. If you're looking for guidance, I've always been concerned about drilling and spacing units being proposed in an effort to do a land grab or to put something together where you can essentially increase the value of your acreage for the purposes of selling it, as opposed to actually drilling wells. So guidance for me, what I would like to see is, like Commissioner Pierce, would be the mineral interest and how they're distributed around the various competing spacing units and the timing, of these folks that are coming forward. They're bringing forth that application First in Time. what is their level of commitment to actually going out and drilling wells? We have capital available. We've had that come where we've asked that question and folks said, we have the money available. We want to go drill wells. And I think that is a pretty important factor for me in looking at that decision. So I certainly would like to see that. I think when you, sorry.
No, sorry. I don't, sorry to interrupt your train of thought, but again, how do we do that? And would a reasonable thought be that timing restriction on the spacing unit itself? You tell me you're going to drill in, within a year or 6 months. Can I make the drilling unit go away if you don't?
As an operator, that would probably give me a bit of heartburn, but it's but it's not an unreasonable.
You're the regulator now.
But as a regulator, I think it's appropriate. I mean, we looked at what happened with the large unconventional resource units in Western Colorado that ultimately did not get developed. And so we have asked to have those dissolved as a result of no activity. So I think that makes sense, is that if you're going to put that in place and you have the stick there is, here's your carrot as you get it, but the stick is you're going to have to make a commitment to go drill. Otherwise the spacing unit goes away. And that, I'm not sure about the specific timing around that. I think our units in Wyoming have either a long period or don't go away, which is potentially an issue because then you can kind of hold that. Although in this particular case, I think that case is going to be a little bit more specific. I don't think you're going to be able to do it except on 1280s because of some of the sage grouse mitigation issues. But here, I think particularly in GWA, they're putting a time frame on that makes a lot of sense. The last comment, and I thank you for bringing that up, because the last comment I have also is with respect to these things where folks come with these master development plans, or don't recall hearing one where that was used, where there was any specific timing tied to that. And it might be 2 years out, might be 3 years out. It's when we get to it or when we work to it. And that has an issue for me with timing around it, back to the timing around mineral development. So again, create the unit, putting a time frame makes a lot of sense. And with a master development plan, just a question about that is, when you have a master development plan, how much of a leap is that to a comprehensive development plan?
Thank you, Commissioner Benton, very much. I concur that we've heard operators tell us they had these big plans, but they had not shared those with us previously. And when we asked them about it, they really hadn't. I mean, I don't mean to question their plans. I know they had those plans and their plans make a lot of sense, but they hadn't taken the next step towards a comprehensive development plan, in my opinion, which is engaging with local government, for example, engaging with CDPHE or Parks and Wildlife if it was appropriate, and not with us. I mean, we didn't know that these were their plans. And I would love to encourage that. And 216's been on the books for a long time and really essentially never been used. I would love for somebody to come forward with a larger scale plan and engage us and engage local governments and say, this is how we see it developing and when, and the big picture.
Question for clarification on Commissioner Benton's line of questioning, if I may, Mr. Chairman. Historically, when we have had proposals for master development plans or had discussions, have those been opposed by anybody? I mean, the reason I ask that is if someone has agreement with all of the interest owners in the master development plan, I don't feel nearly as pressured to come up with some timing restriction. But I don't know what happens if somebody proposes a master development plan and somebody else opposes the creation of the approval of that. I just don't know.
The one case that I remember, Commissioner Pierce, it was an applicant that had a small acreage block and wanted to develop it and clearly had the capital and the intent to go forward. and opposed the master development plan because there was nothing specific about when that was going to reach that area. They had no opposition, said it made sense to do that, but it was so far out in the future that they needed to go develop it now, so they opposed it. So that's where I get back to the timing. And as Director Lepore said, timing is important.
Okay, that's helpful. Thank you, Commissioner. Thank you. Rick.
My memory is very consistent with Commissioner Benton's.
Commissioner, the floor is still yours. Do you have
Oh,
additional?
no, I'm through. Thank you for now.
Commissioner Holton, just want to make sure we still have you on the line if you wanted to jump
I'm still
in.
online. I got a couple comments, Mr. Chairman.
Mayor, please.
I think I agree with Commissioner Pierce and Benton that I think it's imperative that we know what those percentages are. In that, whether it's a 1280 or 640, I think it's imperative for me, at least, to make a decision on what we're going to do going forward. I know on permits, you know, this master plan that we're talking about and putting a time limit on it, they do it with gravel pits all the time. You know, the gravel pits will get permitted and they get their USR from the county or from the city, whoever. And then if the economy goes bad, they've got to come back in 2 years and say, you know, the economy was bad, so we didn't do it. So they extend that back out, but at least it gives us an opportunity to say, and we do it at the city too with developments. I mean, if they come in and they get approved for a certain development and they don't do anything for, 2 years, we can vacate that permit. But it gives them an opportunity to come back in front of the commission and say, okay, this is what's going on. Price of oil went down to $20. We're not going to do this right now. But at least that gives us something that we can review after a 2-year period.
You're getting lots of thumbs up and heads nodding here, Mayor. Thank you for the comment. Additional?
If I may,
Commissioner Jolly.
I agree with what Commissioner Holton just said. I think, and the other commissioners, as far as knowing what the percentage of ownership is got to be helpful in some of these decisions. And that some kind of timeline is appropriate as well. It may help them get their foot in the door to already have had this when they come back in a couple of years, but I don't think it should be open-ended forever. Should there be any consideration here, or how big of a factor is small operators versus the larger operators impacted by the discussion we're having?
Director?
Thank you, Commissioner. Thank you, Mr. Chairman. Commissioner, I think it is a factor, and it will be interesting to see how it sort of plays out. And it does, at least in my mind, and some of these examples would bear it out. I always struggle with an operator who comes and says, we have a high percentage, 90%, 80% of a 320, and we want to develop that acreage. And somebody is coming in and saying, we're gonna make that part of a 640 or a 960 or a 1280. Well, I think those are hard conversations, because if it's all going to be 1280s, you probably are tilting the scales towards operators with, bigger positions in the basin. So I think part of this discussion is that it's still going to be a case-by-case assessment. I think in one of the illustrations here, and it is the one that's on the screen, the proponent of the 1280 had less than 50% of the 1280, and the proponent of the 640, we think, had more than 50% of the 1240. 640, sorry, 1280, 640. I think that probably comes to you to balance those two things out. But at least we know that we're not just saying 1280 is better. And you can make the decision about whether somebody with 40% should for a variety of reasons, get the nod over the person that had 80% of the smaller proposed unit.
Thank you.
Commissioner Rager.
So Director, you indicated that some of the applications that are in the pipeline right now are providing a lot of content on approval from local governments in advance. Is that beneficial to COGCC staff? Does it make it easier if they come with that in hand?
Thank you, Commissioner. I may have overstated what I believe is true. There are some. I am aware of some. And the short answer is, I think staff views buy-in of local governments as a relevant, if not important, factor. Along the Front Range, in this day and age, if we know an operator has engaged with the local government, and look, this is what the governor's task force rulemaking was really all about. That was limited to the large urban mitigation area facilities. Many local governments have adopted ordinances or strong desires for operators to engage with them ahead of coming to COGCC. That's not in our rules, but operators are, in some cases, choosing to do that. And if they choose to do that for whatever reason and come here and say to the staff, the local government supports this, and the competing operator could not say that, I have to tell you, I would lean in favor of the scenario with support from the local government. Whether that takes the form today of tilting our recommendation, not sure I can say that, but I don't know how you could ignore that factor.
Thank you.
Thank you, Commissioner Rager. Thank you, Director. Other commissioner questions, comments, guidance? I think
Mr. Chairman?
Please, Commissioner Holton.
Being the local government representative on the commission, if an operator comes in and talks to the city of Fort Lupton beforehand, and we can get a lot of these issues mitigated, that's huge for me. And that's going to be huge for any other municipality or county.
I think that's a great point, a very important factor in my mind as well. And I think one of the things you're really asking us for, Director, is, there's no question we're seeing more of this issue consuming staff time and frankly the commission's time. We have precious little time to meet as a body, and we are spending a lot more of our time on these questions. But I think certainty or clarity and kind of the rules of the road are important to all involved. And I know that's why you're asking for our input. I don't know if we've gotten as far as you had hoped today, but I think this input has been meaningful, and I would suggest we're not done. My guess is there are operators out there who would not yet feel certain as to what the process will look like and what criteria will be taken into account. Commissioners, might it make sense for the Director to work with staff, reflect on our guidance today, and circle back, obviously in open forum with a proposal of how the commission staff might treat future applications in this situation? Do you feel you've given enough initial guidance? Please, Commissioner Benton.
I'm curious, Director, if either you or the staff have had any comments from operators as to what they might like to see.
Great question.
Commissioner Benton, we have, I would say, less formally than what we've done today, we have teed some of these issues up with operators. But to be candid, as I said at the beginning, we this conversation initially started out focused on 318A. And so there were several factors around 318A that we had floated to them as things for future consideration. In cases of some of these individual disputes or conflicts or competing applications, we have touched on some of these factors in our staff meetings and pre-hearing conferences with them. I think today probably is the most formal and organized presentation of these issues to the operators. I'm happy to carry this forward and meet with operators through the trades or something like that to hear feedback and I'll stop there.
I'm sure you'll get some, so I don't know if it's, or maybe more than some.
Are you sure?
Well, I was thinking about Commissioner Pierce saying making some assumptions, and I always worry about what happens when you assume, but I think it's safe to assume that you'll probably get some feedback, but I think I would notionally say that there's a fair amount of guidance that I've heard today from the commissioners that we can proceed.
Looking around the commissioners and Commissioner Holton for consensus as to whether that's the appropriate place to leave it for today.
Mr. Chairman, if I may.
Please.
I do think the appropriate place to leave this discussion is there's no firm outcome from this discussion. I appreciate staff working on these issues and trying to make processes and understanding more clear. I appreciate the indulgence of the commission and staff as I sort of started to grope through these things. I'm going to continue to grope through them. I hope the staff will, but I personally do not have any motion that I am ready to make about anything to be done differently. So.
Fair enough. I think I'm in the same place, frankly, but we were asked for input. I think there's been some very, very good ideas have floated, and I think good perspective, for example, from local government and from operators. And Director, if you're comfortable, I think, commissioners, that it would be where we leave it today. And I agree, we don't have a new regime yet. If I were an operator, I don't know that I would know what the rules of the road are, but I would feel comfortable that the issue is squarely on the mind of the commission, obviously, and it's being thought through.
Thank you, Mr. Chairman.
Please, Commissioner Holton.
Are we looking at the direction that we gave today, some of the input, as a policy change, or is that going forward as possibly a rulemaking?
It's a great question. I mean, I think the director started the conversation, and I assume that's the legal position thus far, is that it is believed that rulemaking is not required to implement some of these changes. But I think that what we're asking for today is is for the director to incorporate this input and come back to us again in public forum with the operator community and others in the room and let us know what the thinking is, how to handle these situations. And I think we, as the commission, can evaluate from there.
Okay, thanks for the clarification.
Of course, I hope that makes sense, at least for the next month when we see each other in February. Does that seem reasonable, Director, to revisit this issue? I don't think we need the briefing. I think we could pick up with the, where are we?
You don't want the briefing again?
The briefing was excellent.
No. Yes, Mr. Chairman, that makes sense. And in that interim, and so our next hearing is March 20th up in Loveland, Colorado. So we will come back to you with some follow-up, and in that interim, we will engage with the regulated community to get their reactions. And I think I appreciate the input very much. It has been helpful and useful, and we'll maybe formalize it a little bit and report back.
That sounds perfect. Commissioner Benton, I think you have one more request.
Just a request. I think this presentation was quite good. I know it wasn't in our portfolio, but is it going to get on the website? I'll put that as a request. Would that be reasonable to ask to have that put on the website?
We will do that.
Great
Thank-
suggestion. Thank you,
thank you.
Director. Commissioners, I would ask if there's any objection to closing out that agenda item at this time. And maybe we'll take a 10-minute break, while the participants and the parties, excuse me, in the first general hearing make themselves ready. Okay, without objection, thank you all for that excellent presentation, great discussion, and we will reconvene at 11:20. Ladies and gentlemen, welcome back. Thank you. That was a few extra minutes. I apologize. Hopefully that gave the parties some additional time to prepare. Let's reconvene, please. This is, we will be hearing a general hearing on docket numbers 170, 100, 080, 081, 082, 084, 085, and 086. The applicant in this case is BP America Production Company, and I will turn it over to Hearings Manager Murphy, it looks like.
Thank you, Chair. I did want to note one thing. During the break, I received a withdrawal of PDC Energy's objection to extraction oil and gases proposed wellbore spacing units. And with that withdrawal, it gives extraction the ability to move forward and submit its APDs and removes that item from the Commission's docket for consideration. So I wanted to let you all know that. And secondarily, I've heard from counsel from Great Western that they're here and ready to move forward with their hearing if that is appropriate before lunch at your pleasure, Chairman.
Oh, very good. I appreciate the flexibility of the applicants there. Commissioners, maybe we see what the timing looks like at the conclusion of the current agenda item. Okay, Ms. Dorncey?
Thank you.
Mr. Rance, excuse me. I'll turn it over to you.
Doesn't matter. I respond to both. Good afternoon. Oh, good morning. Jill Durante, I'm the hearing officer for this matter. These docket numbers 17010081, excuse me, 80, 81, 82, 84, 85, and 86 are all applications filed by BP America for sections 26, 27, 34, 35 of Township 35 North, Range 6 West in La Plata County. These matters are being presented to you because together they represent a novel proposal of overlapping units outside of the greater Wattenberg area for horizontal development. Specifically, BP requests 2 640-acre drilling and spacing units and 4 480-acre units with 2 new horizontal wells within each unit. The information is included in your portfolio, and placed before you is also the PowerPoint presentation, which includes supplemental testimony. Staff recommends approval of these applications at this time. Due to the challenges in the topography in this area, the reduction of surface disturbances, lack of development in this area, and their location is at the edge of the basin, we recommend approval of this application. These matters are all unprotested at this time. If there are any questions at the end of the presentation, Stuart Ellsworth, the engineering manager, as well as Jane Stanzik, the permitting and technical services manager, are prepared to answer questions after BP's presentation. At this time, I turn it over to BP for their presentation.
Mr. Chairman,
Please.
before we start with this presentation, I just feel like I need to make a disclosure. I've worked for BP for many years and I'm very familiar with this area. I retired in 2009 and I am not currently employed by them. I feel like I can be objective and not be influenced by that prior work in my decision on this case. So I'm not asking to be recused, but I did want to make sure that the commission was aware that I'm familiar with this area and I've worked with this company for many years. So.
Very good. Thank you. Duly noted. Are there any, I should have asked earlier, and I apologize, Commissioner Hawkins, any other disclosures or potentially recusals? Hearing none. Let's, Ms. Spencer, you were about to begin. Thank you. Welcome.
Good morning, Commissioners. My name is Liz Spencer with Spencer Legal LLC here on behalf of BP America Production Company. I'm going to start out with an introduction of my colleagues who are here today. Two to my left, I have Scott Hammond. He's a senior landman at BP. I have to my right, Robert Moore. He's a reservoir engineer. In order of presentation, Scott will go after me. Bob will go after Scott. And then to my left is Chris Sandoz. He doesn't have a formal role speaking today, but he's been integral to the project. And then back in Houston is David Schoderbeck. He's the geoscientist who did the geology on this. Bob is experienced enough that he's going to present both, but he was also integral to this project.
Great. Well, thank you. Welcome, everybody. Do we need to swear witnesses? Mr. Schultz, for those who haven't met or been introduced, Assistant Attorney General Scott Schultz here today in lieu of Mr. Matter.
Thank you, Chairman. Do you swear, would you please stand or raise your hand if you were to testify here? Do you swear to tell the whole truth and nothing but the truth?
I do.
Sounds good.
Thank you. Ms. Spencer, please.
Starting with the project overview, as Jill said, this is a request for 6 spacing applications in La Plata County. This is the general project location in green. It's a 4-section area. It's about 5 miles from the town of Bayfield line of sight, and we're just north of the reservation boundary. As you can see, it's a relatively well-developed area. Bob will probably touch on this soon, but there's a fair amount of infrastructure here that will accommodate the production that will happen on these lands. This is what the project looks like right now in the beginning of the presentation. It probably makes no sense to you. We'll come back to this slide at the end, but I wanted to show you the end of the story at the beginning of the story. The purple and pink is going to be 1 unit. There's 4 stacked on top of each other, those 4 80s. East Salls Creek 26-1, you'll see the names on the far right. Those are the 4 units. And then those overlap with the yellow and orangish ones on the left, YFA, Yankee Federal, YFB, Yankee Federal B. And you will also see the well orientations going to the west and to the east. Like I said, this will make a lot more sense at the conclusion of the presentation, but this is where we're going. So BP seeks overlay horizontal development in a 4-section area, 35 north, 6 west, La Plata County, Colorado. The reason we seek overlay horizontal development as opposed to the traditional standalone drilling and spacing units that you may be accustomed to seeing are 4 main reasons. There's rugged surface topography. This is, as Jill said, at the end of the basin, and it's difficult to physically access. Portions of the project area in the Forest Service roadless area, which obviously means it's impossible to access. There are seasonal closures, December 1st to April 1st, which means that the drilling timing has to be quite specific. And there are existing vertical and directional wells and federal CAs, which when there are producing federal CAs, those actually can't be vacated. So there are several in this area, which makes it a challenge to vacate the existing spacing and establish a new unit because there's existing wells subject to these CAs. There's some project benefits here. There's very limited surface disturbance. All development in the 4-section area occurs without a single new surface location. So there are 2 wells associated with each 480 and 2 wells associated with each 640. So that sum total only requires no new surface location. And then finally, the units were designed to be no longer than the size needed to accommodate the proposed wells, which is why we have 4 480s and 2 640s. The idea being to respect the correlative rights of those in the units without making the units any larger or any smaller than necessary. And then finally, the success will support additional innovative development. There's been horizontal drilling in this basin since about 2005, but this innovation will allow BP specifically, and possibly others in the future, to access minerals in otherwise inhospitable areas. The challenges here are actually what forced the technology and forced the innovation to create this project. And Bob will talk more about this in a little while. I want to talk a little bit about the preparation timeline here. The project started, or the planning for the project started in March 2016, so a little less than a year ago. BP started an internal planning process, and we also came here and met with the commission to kind of discuss the overviews of the project. In April 2016, then BP met with the U.S. Forest Service and the BLM Trace Rios field office to get the BLM buy-in. Continued preparation up until the application date. And we met again with the commission in November 2016 to kind of get the contours of the application. What would you like to see? What do you expect from us? What kind of problems or issues do you anticipate? In December 2016, we filed the application. In January 2017, only about 2 weeks ago, we met with the BLM in Lakewood to address some issues associated with setbacks. All these issues have been resolved, but it's been a pretty intensive process to get the application here today on this docket. Local and federal regulatory background. This project is located in La Plata County, Colorado. They have a pretty predictable process for becoming involved in spacing applications. Here, however, the LGD received a copy of the application, and Counsel for BP actually contacted the LGD, but the project is on federal surface, so La Plata County did not intervene. It's outside their jurisdiction. The BLM was also heavily involved here. They requested and BP agreed to language about communitization agreements, which is pretty standard. And there were also some concerns about non-reciprocal setbacks. Most of the lands here, and I'll discuss the setbacks and the spacing in a moment, are 990-foot setbacks. And in several areas, we were requesting 660. And the BLM is reluctant to allow non-reciprocal setbacks. They don't want a unit where they have acreage to be 660 where the neighbor is 990. So your supplemental testimony, which is at the back of the packet we sent you, we met with the BLM, we discussed the issues, and the solutions for their concerns are in that packet. In addition, on January 25th, so last week, we submitted an application for setback reduction in section 28 to fully alleviate the BLM's concerns. We expect that will be docketed and approved in March because the only interest owners in that unit are BP and the BLM. So this is the existing spacing. The lands are 320 acre spacing, generally speaking. To the left, those lands are currently developed, so you can see the units exist. To the right, those lands are where we're going, but they're currently undeveloped, mostly because it's a roadless area and other challenges to reach those minerals. As I said, it's 320 acre units. I'm going to go through this quickly. Existing wells and federal CAs exist on those wells. Orders 11260, 61, 85, and 156 apply to all. Generally speaking, allow up to 2 wells with 990 setbacks. For section 35, 112.214 allows up to 4 wells with 660s. That's just kind of a high. For the most part, our application reduces all setbacks to 660, except for the very most northern boundary. The implication of 112.214 is certain areas didn't get reduced setbacks. And this is the East Salls Creek units. This is an underlying slide of the slide I presented to you in the very beginning. These show the 4 units that are the East Salls Creek project, 26, 1, 2, 3, and 4 from north to south. And each of them is 480 acres. Basic overview of what we're looking for here. Each of those 4 purple units will have 2 horizontal wells in a unit. One is a multilateral well and one is a service well. Bob will talk more about the service well before, but it exists to service the multilaterals and dewater them. Because of the geology, the dewatering well is necessary, so that comprises the 2 wells. They overlay the existing 320s, which are currently in place. They will also overlay the Yankee Federal 640s, which I'll talk about next. These all have 660 setbacks except for the very north boundary. So that's the top of section 26, that's a 990. All the others are 660. We will be statutorily pooling the East Salls Creek 26-1 and 26-2. Those are the top 2. And all wells will be drilled from existing surface location of the Yankee Federal wells. And I'll show you what the well orientation looks like. So the Yankee Federals you'll see on the west side, those are existing wells. The development will come from those locations and go to the east. These are the Yankee Federal units. These are section 27 and 34, which are to the east of what we just saw. The Salls Creek units partially overlay them. These are 640 acre units. These will have 2 multilateral horizontal sidetrack wells. At the bottom, I said a note for a sidetrack well. The difference for a sidetrack as opposed to the horizontal drill that's happening in the East Salls Creek is we are re-entering an existing producing directional wellbore, cutting a hole in the casing, and the horizontal lateral will emerge out of that. So you will see that's the wellbore orientation. We're using the existing Yankee Federal wells, and those 2 sidetracks will emerge from that existing well. And the final slide here shows you what the project looks like together. We're using those Yankee Federal wells and going west and east, and then showing you the overlays of section 27 and 26 and 34 and 35. Next, I'm going to turn it over to Scott Hammond, who's going to give you the land testimony and the ownership of these units.
Thanks. I'd just like to say this is my first time to testify in front of Colorado Oil and Gas Conservation Commission. I appreciate you allowing us to be here today.
Well, welcome, Mr. Hammond.
Let me say in general, I'd like to just give you a general overview. You've got slides. It's pretty easy to follow through slide by slide. So I'm going to give you the way I approach this, being a senior land guy. I was tasked with providing opportunity to new wells to access acreage that we were challenged from the topography surface to get to. Then we were also wanted to drill horizontal sidetracks from existing well bores. And the issue we're going to have is we're going to use the same well sites for both operations so that we had no additional disturbance on the surface. So given that you have two separate 640s side by side, you're going to have overlap somewhere when you're coming off unit to drill your new wells from an existing well site to drill your horizontal sidetracks. So that's what I had to deal with. And so I kind of like to take things and do it in bite-sized pieces. So what I did initially is just looked at my East Salls Creek new drills. So that's what we have in our first slide. And let me say that these are 480 acre units. The top two units, the 26-1 and 2, we would have partners. If the partners chose to participate, we did have unleased mineral interest owners in those tracks as well. So what we did is in the 35-3 and the 35-4, that was 100% BP, and we didn't have to worry about statutory pooling in those two sections. So initially what we did is we had to decide how to propose these to partners, to be honest. It's a little bit different concept than what we've used in the CBM stuff before. And we also were going to use what we were calling a 2L system, which Bob will elaborate on more. But we're going to have one well bore, horizontal well bore, long well bore, was effectively going to be a triple stacked. We then, with concerns for dewatering that, we were going to drill what we were calling a service well, which Bob, again, I'll defer to the experts for that. But we're going to have to propose wells, get people to elect, because you're going to have to pay for two wells. We have two well heads. They're probably both going to produce gas, but our primary well was the triple stack lap. So that's what we did. We tried to be fully transparent with partners, to let them know what we're going to do. And to be honest, I think we must have done a pretty good job, because the only responses we got besides participation or we'll lease was finally somebody's going to be able to develop this acreage out here, because people had long-term HBP acreage they hadn't been able to develop in a while. So generally going through the individual 26-1, the East Salls Creeks, you can see the configuration. We used a 160 in each one of our units. It was going to be the 160 where the existing well pads were in the Yankee Federal A, the Yankee Federal A1 or 2, the Yankee Federal B1 and 2. So all of the east side of that unit would be included in our overlays, 160 acre at a time. What we did is, as you can see the breakdown, the majority of the lands that we were dealing with were federal lands. They were HBP lands, except for 280 acre tracts that were unleased, which we know we're going to have. We've talked to BLM. We'll have to provide for an unleased mineral account until they finally put those two tracts up. But we didn't identify those because you couldn't statutorily pool them. We'll be paying the cost of that up front. So in section 21, we had the only fee tract in all of our 640s. We were successful in leasing the majority of that. We also, our overlays, we limited to the two wells. So they excluded any well that was existing or any future wells. So the 320s were saved, the 320 underlays, if somebody wanted to come in at a future date and drill wells there. As I zoomed through the 26-1, the forced pooling, I think we ended up with roughly 60 to 70 acres where third parties, either we didn't know if they'd leased, they wouldn't lease to us. I think they probably committed to a third party. And then we had a surface owner who held 60 acres that chose not to be statutorily pooled for that reason. He just felt like he might have a better chance of protecting his surface from future development by doing that. 26.2, we only, same concept. We had a 480 with the Southeast 160 with the existing Yankee Federal A2 well bores where we drill our triple stack lat from. We had one 40-acre federal lease 8 long-term HBP that the working interest owner elected to participate, not to participate, I'm sorry, elected to term assign us their acreage. But that led to really good discussion simply because they have a large federal position offsetting this to the east, and we're providing an opportunity for them to think about how they might develop some of their leasehold over there as well. So the pooling part of that was we had one committed working interest owner going in that we filed the forced pooling application on, and we came out with no uncommitted working interest owners. In 35.3, 35.4, all we required to do there would be our overlay spacing application along with any setback reductions we needed. We had 100% of the working interest in both of those two, the 35.3 and the 35.4 from a working interest position. And given that we had no statutory pooling, these were pretty straightforward. Then my mind had to get around doing something differently, and that was using existing well bores and kicking off horizontal side tracks going the opposite direction from the existing well path or the well bore, the vertical wells that were sometimes directional, kicking back to the west to fully develop the two 640s there. And what we did is both of those were 100% BP. The section 35 or 34 was 100% federal. To the north, we had 200 acres of fee, and we contacted those owners as well, just to let them know what we were doing. They were noticed. We also had to exclude any existing well bores, which Bob will speak about for allocation purposes, because you had 4 existing vertical wells in both of those 2 sections that we needed to be able to allocate production. And we weren't going to, we're going to be producing one well bore to the surface, two wells. So with the Yankee Federal units, that we had no comments or objections from anyone with any of the things that we proposed to do, which I felt was a very successful effort, especially given that you had people, you had parties out there with working interest, with 2 AFEs sitting on their desk, not really understanding the concept yet, and except the party that the term assigned, they all elected to participate in our wells.
So we'll turn to the geology and the engineering aspects of what we're planning to do here.
It's Mr. Moore, right?
Yes.
Could you reintroduce yourself, please, to the
I'm
commission?
Robert Moore. I'm
Thanks.
a reservoir engineer with BP.
Thank you.
Been with them for 45 years.
Thank you, Mr. Moore. Welcome.
There we go. Okay, so just another screenshot of the application area. I'll focus on where it is in the basin, though. We haven't really talked about that. It's way up in the northeast part of the basin. We did mention it's on the eastern edge of the developed area. BP's efforts and other operators are really focused on the eastern side of the basin as we look at this year's and future years' drilling programs. This part of the basin has been nearly all developed on 80-acre spacing, according to the infill order rules that we've had here. This is the fairway, which is still spaced on 320s and is fully developed on that spacing. But you'll see some openings and some gaps on the east side, and then as we go further to the east, very little development has taken place, and that's because this is where the mountains are. We've developed up to the edge of the mountains, getting development further east, although there's certainly fruit and coal present. And in the early days, there were a few wells drilled out in here, so we know the coal is there, but just hasn't taken place because of the difficulty of the terrain. This is a little closer in shot showing some of the terrain, the 4-section area that we're talking about, outlined in black And a little darker gray is the roadless area by the U.S. Forest Service. This is an area called the HD Mountains, famous for their old growth ponderosa pine forest. And so it's a very sensitive and environmental area, no roads allowed. Although BP does hold leases not only in sections 26 and 35, but also 1, 2, 11, and 12 as we go further south. So we're trying to develop innovative ways to develop this acreage without actually getting into the roadless. The type log for this area, we're talking about 3 coal seams within the Fruitland coal that we designate the Bayfield, which is the uppermost, and then the Lemon and the lower Lemon. And this is from one of the Yankee Federal wells, and is the geology that we're targeting. We mentioned that we'd have 3 horizontal laterals in our wells going to the east. Each of those laterals is targeting one of these seams, the Bayfield, the Lemon, and then the lower Lemon. Structurally, it's a very complex area. To the west of us is what's called the Bayfield anticline. So this is a structural high position. We know it's there because we've got a lot of wells that have found it. Great well control. And as we go from there to the east, and as we run to the edge of the well control along here, we know the dip is plunging from west to east, and then at some point it turns back up to the outcrop, which is out here. But where the syncline axis is, we don't know yet. And so we'll be testing that as we drill the laterals. We'll be starting them in the down dip position, and we'll find where that syncline is as we drill these. Partly because of the uncertainty in the structural geology is why we want to start our development in the north, where we have the least risk of coming on the other side of the syncline, which is something we don't want to do. And then as we go further south, we'll have a better control over what the geology is, and better planning how we develop those southern sections with the horizontal laterals. This shows a reservoir model that I've constructed, and it shows in 3D view the structural dip I'm talking about. This is, I use this as a way of calculating gas in place, among other things, and predicting the production to be gained from the development. Overall, in the 4 sections is about 135 BCF, ranging from 32 to about 35 BCF per section. So a sizable resource. Development to date has concentrated in the Yankee Federal areas in sections 27 and 34. When we were developed on 320 acre spacing, we got up to about 1.3 million a day from our 4 wells, and another 4 wells were drilled on 160 acre spacing in about 2007. We hit a short peak of 3.5 million a day. Then it's been declining since then. So we're producing about 2 million a day from the 8 wells this year. On a recovery basis, as I project this production out into the future and what these wells ultimately recover, it's fairly low given what we're doing in areas where we developed our leasehold on 80 acre spacing. In section 27, I'm expecting about a 33% recovery. In 34, where the wells are a little better, a little higher recovery of around 50%, and overall about 42% of the gas in place, just in those 2 sections, not in the whole 4 section area. That would compare to recoveries on the order of 70 to 75% where we've developed on 80 acre spacing. So there is a development opportunity here, even in the sections where we do have wells. This shows a cross section geologically of how we're planning to drill the laterals. As I mentioned, we'd have 1 lateral going east in the Bayfield, 1 in the Lemon, and 1 in the lower Lemon. These would be from a new well that we would drill. And then there's the service well that we've talked about, which would be drilled actually below the coal in the Picture Cliff sandstone. Would be completed though as we come up into the coal, only in the coal, and would be cased and cemented throughout the sandstone interval. And its purpose is to help us dewater the horizontal laterals that are in the coal. This is an issue that you always need to be thinking about in developing a coal well with horizontals, is how do we get the water to move along the lateral? And normally we prefer to drill our laterals up dip so that water just gravity drains back into the producing well. But in this case, because of no access that we can come over here and drill from. We're by necessity drilling our wells down dip, or what we call toe down. And so without something to remove the water from here, the water will just remain in the lateral and the well won't produce, basically, is the problem. So we've, in this area, and this is something we've never tried before to this extent anyway, we're planning a separate dewatering well, which will come up, cross through the coals, and in the driller's graphic, it shows a little better the true scale of this. So we've got our 3 laterals in the coal, our dewatering well, which is below it, comes up and crosses the coal sections. These well bores don't actually intersect, but they're going to be close together. And we'll frack the coal in the blue or the dewatering well. The laterals in the coal will not be fracked, but in order to establish the connection between the dewatering well and the horizontal laterals in the coal, we'll frack it. So we'll have 3 fracks per well. And the water will drain down and will be collected in the blue well, where we'll place an electric submersible pump and pump the water out. And so that's our scheme for doing this. And if, again, this is kind of a test, we'll be trialing this out, but if this works, then we can continue with this type design as we work our way south. Production forecasting, and this is based on the types of rates and recoveries that we're seeing in other horizontal wells that we've drilled in the basin, particularly in the Allison and Tiffany areas. Expecting a peak rate of just around 3.5 million a day. And because we're developing 480 acres with the well, it's expected to be a fairly high recovery well relative to other wells in the basin, a little over 12 BCF. And also our horizontal sidetracks we talked about, showing here, would come out of the Yankee Federal A2. And as we go to the west, the Bayfield is really not present. So we're only drilling 2 sidetracks to the west, the Lemon and the Lower Lemon. And they're a little shorter in nature. So my forecast for that is, again, a nice high peak rate, a little over 2.5 million, but it drops off sharply from the peak. And we get a little lower recovery of about 7.5 BCF from those. Again, they're shorter in length, and there's also other wells producing around them. Overall, with this development, the 4 new horizontal wells going to the east and the 4 sidetrack wells going to the west, we should see production grow from about 2 million a day to hopefully over 20 million, and improvement in recovery from just under 30 BCF with the current development to close to 90. So this is adding about 60 BCF of recovery to this 4-section area. So that concludes the technical presentation. Is there any questions or?
Thank you. Commissioner, questions? Commissioner Benton.
Thank you. Just a couple of technical questions. Interesting approach to a big challenge there. Did I hear you that you said you were going to cut a window in your existing well bores?
Yes.
And you'll be able to maintain production out of the existing horizontals? Is it in the horizontals that you're cutting the window, or is it in the vertical?
No, the window will be in existing vertical wells.
Okay.
At least they're vertical through the coal. Some of them were directionally drilled, but they're through the coal. They're vertical. We'll be going in there, milling out a window to drill the horizontal side.
So you'll still have retained the horizontals are on the same location,
right?
To go out into the Yankee
Yeah, so that's all being done off of this one well pad.
Okay, thanks.
Yeah.
I'm sorry I missed that. I was thinking, how in the world are you going to be able to keep all that going?
The sidetracks, we've done those before. We've done 12 or 15 horizontal sidetracks out of existing producing wells.
Yeah, existing verticals. It's not too bad. So.
Not too
Okay,
bad.
thank you.
Commissioner Benton.
Mr. Chairman, if I may.
Commissioner Pierce.
Mr. Moore, I apologize. I almost interrupted Liz and I almost interrupted Mr. Hammond. So you win.
Okay, yeah, so you want me off the
And I apologize. There's just some things I need you to explain to me.
Okay.
Mostly because I'm just interested. I look at the graphic display of the well bores, and there were several of them. If you'll pull one of those up for me.
In plan view,
Early in Liz's presentation, she was walking through the East Sauls Creek units, 480 purple. Looks like slide 12. If there's a plan view.
Slide 8.
No, go a couple of slides further.
This one?
Yes. Well, that'll do it if it shows the wellbore.
Yeah, I'm looking.
Slide 12 will do it if you.
12 or
Yeah, there you go. Okay.
Okay.
What's going on with those well bores on those 4 spacing units shown
Okay.
there? I mean, do they really diverge and then rejoin?
They don't join where the wellbores actually intersect each other, but they diverge really for drilling purposes a little bit. And then so we bring them into a same kind of target area at the end of each lateral. And we're aiming for something around 50 feet in diameter that they all come into. Now they're different coals, so they're stacked vertically.
Okay, what I was interested in is why are those well bores converged at the western
That's
part?
so
of that?
we're bringing all the water down to that point. And this is also where the dewatering well, which is coming up from below, will come into this same kind of 50 diameter cylinder, if you will. And that's where we're going to be collecting the water.
On the west, far west of these.
On the far east in this case.
East, I'm sorry.
On the far,
Yes, okay.
So it's all about getting the water out. And so we want them close together at
All
their
right.
toe
And-
ends.
And then again, just because I don't understand. When the type log was shown, you're going to put one well bore through each of the 3 zones. Is that what you were
Which one was
saying?
that?
And we'll try to direct each of them. Looks like, I don't see a slide number,
Yeah, there's no
but the
slide.
type log.
Coming up pretty quick here. This one. Right, so
Yeah.
the producing well, so that we expect to get most of the gas. We'll have laterals placed, one in the spay
Right.
field, one in the limb, and one in the lower limb. And those will be going in down dip to this point of convergence. And being coal, and this is an area that where with no development has still not yet been dewatered. So the coal will be initially 100% water saturation. So we need to remove the water. So the water will flow into the laterals first from the reservoir. It'll gravity feed down to this point of convergence where we'll have another well where we're going to be pumping the water out from there. In other parts of the basin, we've done something similar to that where we could actually place a vertical well near the toe end of the laterals and we pump that vertical well and we remove the water that way. In this case, though, because of no surface access, we're doing everything from the one location, surface location on the west side.
I appreciate that, Mr. Moore. One more question, just because I'm interested. How do you complete horizontal coal wells?
We just we drill open hole and we run a slotted or pre-perforated liner. We do not cement it. And we just drop the liner off in the coal.
I appreciate your patience. Thank you, sir. Thank you, Mr. Chairman.
Thank you, Commissioner.
Mr. Benson. Sorry. Every time you ask a question, I think it's something else. Sorry about that.
We will see.
Just curious about what do you do with the water? Because you're gonna get
We have a water
a lot of
disposal
water
system
here.
in the basin. And so the water will be collected at the surface location, which is already connected by pipeline into our disposal system. And will be pumped and piped to one of 17 disposal wells that we have around the basin.
And no active water drive from underneath. This is all gonna drain down.
It's close to the outcrop where there is some water coming in, so we may see some water in the coal.
Okay.
And we do see some of that in our other wells in this area.
Okay. Thank you.
Okay.
Commissioner Hawkins. Bob, I had a question about, sorry, I'm pretty familiar with Bob. I call him Bob. Mr. Moore,
Yes, Mr. Hawkins.
are you going to have a pumping unit on the horizontal at the surface?
We'll run an electric submersible pump in the dewatering well,
Okay, in the service well.
in the service well, yeah.
And then what about, is that a separate,
It's a completely separate well
okay.
from the well with the 3 laterals producing from the coal. So it's,
And my question is on the well with the 3 laterals that are recover gas, are you going to have a pumping unit or some kind of?
we're set up to run a pumping unit in that well if we need to, if we're getting water up into that well, which we might in the beginning days, but typically it will not be pumped.
So are you going to start with the dewatering well to give it some lead time to try to pull the water off the coals in that area, or concurrent, or?
We'll drill the dewatering well first so we know where to place the laterals in the coal, and then we'll put everything on production concurrently.
Yeah. Good.
Okay.
Thanks.
Ms. Spencer, I think this question is for you, if I may. How could you characterize where things stand with the Forest Service or BLM? I know that's a combined service first office down there.
I think we're approved. The BLM, like I said, had some issues with non-reciprocal setbacks. We met with them. I met with them last week, and the ownership in the majority of these units is the same on both sides. When we explained that to BLM, they said, "Oh, the federal minerals interest won't be harmed." So I think we addressed probably. I think there are about 6 non-reciprocal setbacks. That addressed 5, and the only remaining was the one on the east side of 28, I believe. And we filed an application last week per the request of the BLM to reduce that single setback to make the 660 we're requesting consistent with that 660 that we requested. And they're happy.
Thank you. Commissioners, other questions?
Happy your miracle work.
Any other commissioner questions or comments? If not, I'd entertain a motion.
Move we approve.
Thank you, Commissioner Benton. A motion to approve. Is there a second?
Second.
Thank you, Commissioner Jolly. Discussion? Mr. Hawkins.
I'm just want to kind of congratulate these guys for coming up with an innovative approach to develop the forested mountainous area over there that for decades now has been a problem of, how would you ever develop that area? And I think, just as Mr. Moore pointed out, that if this is successful, that there's more area that could be developed similarly with horizontal development and probably more service wells. But I do think it's there's a significant amount of gas there that could be recovered, and looks like a good novel approach on trying to recover that without disturbing the surface.
Very good. Thank you, Commissioner Hawkins. Further discussion?
Call the question.
Thank you. Just for my own edification, is Commissioner Holton still with us, or is this?
Yes, I'm still there.
Okay, great. Thank you. Okay. Well, hearing none, let's call the question. All in favor of the motion on the table, please say aye.
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 Thank you, Commissioner Holton. Opposed, nay. And we'll register my vote as an abstention, please. The ayes have it. Congratulations. Thank you. Thank you for your testimony and participation today and your excellent presentation, Ms. Spencer. Commissioners, it is 12:10. We have a general hearing scheduled at 1:15. The parties are here and I believe have indicated at least a willingness, if not a request, to move along, but it's also the lunch hour and there was a contemplation of an executive session. So I'll leave it to you, commissioners, if we want to push through and have what might be the last.
Yeah, I was going to ask, Mr. Chairman, do you understand that is the only matter? remaining?
I think, Ms. Murphy, we still have enforcement hearing docket number 161200550 regarding Petro Hunter Operating Company.
Yes, sir.
Are those parties present?
Chairman, I believe we anticipate Petro Hunter to not appear, and so enforcement staff is prepared to go at the commission's request. And if I may interject one more comment, my understanding of the Marilex case is that we could stay any executive session discussion of it to March without any problem. So.
And that's the only issue that we had noticed for executive session.
That's correct, sir.
In other words, if the commissioners felt so inclined, we could stay that and not have executive session today.
That's correct, sir.
Okay. What's commission's pleasure? Shall we move on to the next hearing, or if we don't have executive session, we don't have to have lunch together? Which I always enjoy.
Could I ask for a rephrase? I'm sorry.
Well, I would suggest the parties are here, we keep moving, if that
Fine with
works.
I agree.
Okay.
Still, Mr. Chair.
Well,
Thank you.
Of course, thank you. Ms. Murphy, would you call the next matter, please?
Absolutely, sir. The next matter on the commission's docket for the commission's hearing is docket number 1701-00056. It's Great Western as the applicant. There is no protestant or objector, and staff is supportive, but it's an issue that we would like the commission to hear and decide.
Thank you, Ms. Murphy. Ms. Drancy, welcome back. We'll give the parties a moment to get settled. While the parties are getting settled, let me ask the commissioners, any disclosures, recusals, or comments of that nature?
Awesome, thank you.
It sounds like we have no disclosures on this matter. So we stand at the ready when you are. Welcome, Ms. Jost.
Good afternoon. Mr. Drancy, would you like to start?
Yes.
Okay, thank you.
Good morning. Oh, sorry, let me grab that microphone. Now it's good afternoon. Docket number 1701-0056 comes before the commission on a request by the applicant, Great Western Operating Company, to reduce the eastern unit boundary setback from 460 feet, which is the default setback in the Greater Wartenburg area, set by Rule 318A, to 150 feet in an approximate 1120 acre unit in sections 25 and 26, Township 6 North, 67 West. The applicant has met with staff at least on 3 occasions. The applicant's engineering team has communicated with staff's engineering team here at the commission. After meeting with the applicant and reviewing the testimony submitted by Great Western in support of its application, staff recommends approval of this application. And I also want to indicate that there is a correction on the agenda. It should reflect that Synergy Resources also submitted a 510 statement in support of the application. It is included in the portfolio on page 21. This matter is not protested. There are 4 or 510 statements in support of the application, including, as I stated, from Synergy, which is the owner of the proposed unit immediately adjacent from this, the setbacks. Based on the unique circumstances presented in this application, which include the limited horizontal development in this area and adjacent to this unit, the agreement of the majority offsetting working interest owner affected by this application, the reduction in surface disturbances and unnecessary wells, and the opportunity to increase reserves at a minimal incremental cost, staff recommends approval of this application. After Great Western's presentation, Jane Stanzik is prepared to answer any additional questions for the commission. Ms. Jones.
Thank you, Ms. Drancy. And Ms. Stanzik, thank you for being prepared.
Great, thank you, Mr. Drancy. Good afternoon, Chair, Commissioners. My name is Jamie Jost from Jost Synergy Law, and I'm representing Great Western Operating Company on this docket number 1701-00056. With me are Ken Cooper and Louis Wadke from Petrotech, and they are the third-party engineering consultants that have been working directly with Great Western on this application specifically and many of its other applications that have come before you over the past several months. And we'll be presenting the technical evidence today.
Ms. Jost, may I interrupt just long enough to swear in your witnesses, please?
Please.
Thank you. Mr. Schultz?
Will those individuals who are to testify in this matter please stand up and raise your right hand? Do you promise to tell the truth, the whole truth, and nothing but the truth? I do. Thank you.
Thank you, gentlemen.
Great.
Please,
Thank
Ms.
you.
Jost.
Well, before we dive into our presentation, we really would just like to take a minute to thank the director, the hearing officers, and hearing examiners, the permitting staff with Jane Stanzik and her team, and Stuart Ellsworth and many others that spent several hours with Great Western on numerous occasions discussing this issue, discussing reduced setbacks, fielding questions, and providing some comments. So thank you very much for all of your input into this application. Just by way of background, the original 1,120 acre drilling and spacing unit was unanimously approved by this commission at the October 2016 hearing. The original application for the drilling and spacing unit requested up to 21 horizontal wells and originally 460-foot reduced setbacks surrounding the entirety of the unit. Upon discussions with offset operators and further analysis of this area, Great Western determined that it needed to file an application for reduced setbacks to 150 feet solely for the eastern boundary of this established drilling and spacing unit. The application was filed on December 1st. Proper notice was given to the interest owners within the unit as well as all offsetting interest owners as required by Rule 507, and no protests were filed. And in fact, the offset operators have supported the application and have either orally communicated their support to Great Western, or as you've seen by the 4, 5, 10 statements in front of you, Synergy specifically as the offset operator and Extraction have both filed 5, 10 statements in support of the application. I'm turning to slide 2 in your packet. What this does is this just illustrates the application's request for 150-foot reduced setback for the eastern boundary of the DSU, specifically for the Codell and the Niobrara formations. Just by way of information, the northern, southern, and western boundaries will remain at 460 feet. The reason being is because there are offsetting wellbore spacing units surrounding that, and Great Western is not seeking any reduction setbacks from those established units. Turning to slide 3, what this is this is an illustration of the interest ownership in the established unit that we're seeking reduced setbacks on, sections 26 and 25. And then the offsetting, I believe, either already filed or soon to be filed drilling and spacing unit with sections 30 and 29. The dark blue lines, I know this is a little bit hard to see, but are permitted horizontal wells. The light blue lines are pending permits. And then we also have the ownership piece here. This was based upon a conversation with the director, as he stated in his presentation earlier, to illustrate some of the interests in these units. You can see that Great Western interests are in yellow, Synergy's interests are in light pink, and Extractions are in the darker purple area. Great Western, if this application is approved with the reduced setbacks, will confirm with the COGCC permitting staff, Ms. Stanzik and her team, that each of the horizontal wells in section 26 and 25 that have their toe on the eastern boundary of section 25 will have the 150-foot reduction approved with part of their application for permits to drill. And then really wrapping up my portion of this presentation is just an overview as to what went into the efforts here. As Ms. Durancy stated, the staff was very welcoming in their conversations with Great Western and met with us on 2 specific occasions with larger groups. And then on a 3rd occasion, Mr. Ellsworth met specifically with the technical team and I to discuss some of the specifics for reduction of setbacks within the greater Wattenberg area. Great Western's engineer, Zach Warren, who is also here in case there's any questions, he engaged in substantial conversations with many operators in the DJ Basin, specifically with the offset operators about these reduced setbacks. And then also, as stated, Bill Barrett Corporation, Extraction, Noble, and Synergy all filed 510 statements in support of this application. So with that, I'm going to go ahead and actually turn this over to Ken Cooper to really discuss the technical aspects of the 150-foot request, and we'll be happy to answer any questions once he wraps up.
Thank you, Jamie. Thank you, commissioners. We wanted to take you on this next slide, on slide 6, that will be in your packets. Wanted to just take you through a brief summary of some of the technical discussions that we had with the staff regarding this application. The way we had proceeded was to look at it from a couple of different perspectives. And we selected 10 Niobrara and 10 Codell wells, which you can see highlighted by the kind of blackish blue and red stars that are on the map there, in relation to the Kodak East DSU that's highlighted in blue kind of in the center of the map. We had performed decline curve analyses on the available production data from each of these wells and established expected ultimate recoveries for kind of a type well, if you will, that we would be proposing to install on these properties of interest. For the Niobrara, we had 227 MBOE, and for the Codell, we had 230 MBOE. So on the next slide, this is kind of a summary of what we had come up with after we had established the EUR. We ended up generating estimates for the drainage areas that would be necessary or that would be likely based on the EUR for the type well based on those averages. This summarizes those parameters, and as you can see, we had average lateral lengths of about 5,556 feet for the Niobrara type wells in the area. We had average Codell lateral lengths of 4,088 feet. And with those values listed, we ended up coming up with calculated drainage areas of 26 acres and 71 acres respectively for the type wells. We then upscaled those, since the proposal here is to be installing a lateral that is longer than the nearby type wells that we had made use of. And we did a simplistic upscale to 8,630 feet and came up with Niobrara drainage of 44 acres and Codell of 149 acres. So this maybe will help everybody visualize, and I know we have kind of different levels of questions and different levels of understanding for everybody. So let me, in everybody's mind's eye, come up with a way to visualize. And some of the folks at Great Western, we were discussing how to best portray this. And perhaps, one way to think about it would be if the lateral well is a skewer, and we've got kind of hot dogs instead of the kebabs on the skewer, the hot dog itself would be kind of the drainage volume, all right? We could also think about it in terms of maybe squashed donuts on some sort of a little pencil or a pole, the pencil or the pole being the lateral wellbore. So this is a plan view that we have, kind of the upper area there, that shows multiple stages that are completed along a lateral. And each of those stages is going to have its own drainage area for sake of simplicity. And if we assume that we've got 150 feet, which is currently the proposed spacing for our frac stages in a Niobrara lateral, we would end up with 44 acres, as we talked about, for drainage, which means that each stage is going to drain about 3/4 of an acre. Okay. And if we run through and do some calculations saying that we're going to assign our radius, if you will, or our distance along the wellbore for drainage as half of that spacing distance, and we end up calculating using Yoshi or Joshi to come up with kind of a simplistic way, and we back calculate what that's going to look like, we end up coming up with drainage of 75 feet and a frac half length of 51 feet. Okay. Well, we also ended up working with the engineering staff at Great Western, and they did a variety of RTA, rate transient analysis work, trying to come up with some matches for what sort of frac half lengths, or, and I hesitate to call them frac half lengths in the Niobrara, but what sort of frac distance do we get that's effectively propped? And we were coming up with numbers that are on the order of that 50 feet. So we're in the same ballpark. So independently, we're coming up with somewhat similar numbers. So what we come up with is an estimate of drainage area and drainage dimensions that is consistent with the setback that we're requesting here. As a matter of fact, we could probably go a little further than we're even asking for, but we're leaving some extra space in order to ensure protection of correlative rights. So let's go to our next slide. And this is the same discussion, the same types of calculations and estimates for the purpose of the Codell drainage example. So in this particular example, we end up deriving our estimates assuming 200-foot staging, so 200-foot spacing between our frac stages. And so that ends up giving us 100 feet for our kind of interwell drainage distance, if we assume that we drain half the distance between each of the frac stages. And in our calculations, we end up coming up with a 300-foot frac half length, or effective propped frac distance, with a 100-foot drainage around that fracture, for an average drainage area of about 3.5 acres per frac stage. Again, the folks at Great Western had been already doing some work taking a look at RTA, and this is reasonably consistent with the types of results they were getting from RTA. It's on that order. So, yes.
I'll forget because I'm old, so I need to ask the questions now. There's a lot of discussion around half length and stimulated reservoir volume. Could you help me explain again what a Joshi radius is?
Sure. Essentially, the idea is that if you have a single vertical wellbore and you presume that you're going to get radial flow into that wellbore, then you'll end up with a circle. If we have a fracture or a horizontal well, you would end up with a situation where that drainage has to be extended along that completion, or that horizontal. So if we have an unfractured horizontal well, which is where that method came from, the idea was that you would have two half circles on either end within a drainage rectangle associated with the actual linear length of that horizontal wellbore. Well, in this case, we're kind of taking it to the next level of scale, and we're applying each of those Joshi or Yoshi radii calculations to each of the frac stages. Again, visualizing as being kind of that squashed 3D donut, or the hot dog of drainage around each of the fracture stages that are perpendicular to that horizontal well. So what we have is essentially a circle of drainage off of each, off of the heel and the toe of a well, or off of either end of the fracture. And then we have a rectangular drainage around the actual fracture, in this case itself. Does that help kind of explain the geometry of what we're trying to chase?
You got a theoretical half length because it's really
Yes,
a
sir.
stimulated reservoir volume, and you backed into that sort of based on your drainage estimates overall.
Correct.
I guess what I was left with when you think about this is it occurs to me that you're making some fairly consistent assumptions about volume, frac volume, pounds of sand per foot of horizontal.
Yes.
Okay.
That is true. What we're doing here is we're assuming that we've got kind of a type or typical frac drainage, and we're applying each of them uniformly, assuming that we would actually have the same performance of each frac stage. Obviously, there will be some variability back and forth.
Right.
What we have not taken into consideration here is the fact that there's probably some overlap, in fact, of our drainage. So that if we're looking at each of our frac stages, do we really have this, perfect no flow boundary halfway between our frac stages? Probably not. And what we've actually got is we've got some overlap there. So our calculations are conservative. And we've done a variety of things to try and ensure that what we're coming up with here is illustrative It's kind of a type completion. And I think the range of the values we're getting are consistent with what we would expect and consistent with what we're seeing in other methods. So the idea really here is to be illustrative as opposed to be deterministic, and to say that we believe that each of these frac stages will really look exactly like this. Certainly we would expect variability.
Just out of curiosity, roughly pounds of sand per foot of horizontal, what were you using?
Well, we hadn't actually included pounds of sand per foot in any of these calculations. That's not really going to weigh in. We were looking at it more from a reservoir perspective. The fact of the matter is that with the fracture plans and the fracture procedures that Great Western has been using of late and intends to use, the RTA analyses that they've conducted on the family of wells in the vicinity are coming up with effective frac half lengths that are on the order of what we've ended up deriving here. So we've done it without using any type of frac half length as an a priori assumption. We haven't assumed frac half length. What we've done is we've back calculated frac half length, found that to be reasonable based on what people have been achieving based on some of their modeling lately, and then it ties in with some transient analysis that's been done on actual historic fracked wells.
I understand if that's actual fracked wells. Curious about, because you had a pretty broad base there when you did that overall analysis.
Mm-hmm.
The amount of sand and the amount of liquid you pump in each one of those sections will give you a different stimulated reservoir volume.
Agreed.
So
agreed.
What I'm concerned with is left is the analog wells that you used, sort of taking a look at how those wells were completed. There's a big variation in those sand volumes and liquid volumes. There potentially is going to be some changes in your stimulated reservoir volume. As you proceed with this development, the assumption would be is that whatever Great Western does is that they stay consistent with that, their existing completion practices as far as pounds of sand pumped and liquid volumes pumped in each stage. So it does have an effect on your, whether you used it in your determination or not. My expectation is that they go forward with this, they're not going to be making any changes in their completion procedure.
I would agree, and I think that always holds true, particularly with drainage distance perpendicular to a horizontal. And so how far do we reach out and touch things with a frac job is certainly going to be dependent on a variety of parameters, as you had properly pointed out. I think in this particular situation, we're looking for what have the values been from averages in the vicinity, and is it consistent with what we can observe from historic performance and what we would intend here? And is it consistent with, in fact, drainage off heel and toe, really? Because I think where we would end up seeing things, if we ended up having a larger drainage or a larger EUR, we would end up seeing that more than likely from drainage perpendicular to the wells, as opposed to drainage off heel and toe. And so really our focus on what we're coming up with here is off of the toe in this case. And so I would absolutely agree with the requirements to have those assumptions be consistent. But I think for the purpose of our calculations, what we're showing is the reasonable nature of the drainage along the wellbore as opposed to off of the tip of the fractures.
Yep. Okay. Thank you.
You had me at hot dogs and donuts.
Excellent, excellent. Okay, so if we can go to slide 10. I think this slide really summarizes why Great Western is making this request, and I think why, at least it's our understanding that the offset operators are to our understanding in support of it. You know, by reducing the toe setbacks from 460 feet to 150 feet in this series of wells to be developed on this particular lease, we're looking at an essential 1 to 2 additional stages per well per formation, okay? So that doesn't sound like much, but the fact of the matter is that it is. It's actually on the order of 40 additional acres of drainage within this single Kodak East development. And so development's more operationally and cost efficient with no additional surface footprint for this incremental recovery. which is attractive, obviously, from an environmental standpoint and also from an economic standpoint. We also have the potential for resource waste being reduced by doing this, because it's pretty unlikely, at least in my opinion, that the strip, if you look at the yellow between those two blue kind of drainage areas, and it gets smaller for the bottom example here, it's pretty unlikely that anybody's going to be drilling a single north-south oriented well between the toes of a bunch of east-west developed horizontals, basically one well off of a single pad. I think that's pretty unlikely. So, I think, as an additional note, I'll make mention that clearly, some reduced setbacks off of heel and toes have been pursued in some other places. This may be somewhat unique for what we're asking for here, but it's certainly been looked at from a general reservoir engineering perspective of this way. And Lewis and I have actually done some of this work other places, other formations. So we think it's a pretty reasonable approach. So for the next slide here, that's just kind of a blow up, going back to one of the slides that Ms. Jose had presented earlier. We're looking at almost an additional well of drainage by having this extended lateral length on each of these Niobrara and Codell producers. So I think that's pretty attractive. We're looking at, in excess of 2 million square feet of additional drainage. And we're probably looking at something like, 30 or 40,000 on Niobrara and maybe 70,000 on Codell, assuming 250,000 MBOE wells. So it's a real volume here that we're talking about. So it's important. So for our conclusions, reduced toe setbacks from 460 feet to 150 allows for 1 to 2 additional stages per well, roughly 40 additional total acres within just this Kodak East development. It increases operational and cost efficiencies without additional surface impacts. Especially when all the offset operators are in agreement, I think it's, the cliche is win-win, but it really is here. I think it makes a lot of sense from multiple perspectives.
Great. Thank you very much, Mr. Cooper. With that, we would like to request the approval of this application up before you, and we'd be happy to take any questions. Thank you very much.
Thank you, Ms. Jose. Let's open it up to commissioners. Commissioner Benton.
I'll make a comment. I had a chance to briefly chat with the staff beforehand. I think this makes a lot of sense in this case. However, I think a lot of it is tied to the cooperation of your offset operators and that they're going to come within 150 feet also. So I guess the caution would be is the support for this doesn't necessarily mean that this would be where we would go across the basin. And I don't want to take a whole bunch of time up here asking a bunch of technical questions for which I have a lot of concerns about what was provided here, particularly background related to individual decline curves, use of cumulative gas oil ratio for your formation volume factors, and just a whole lot of things that probably need to be established if we're going to go do this again. There needs to be some additional information brought forward. Nevertheless, based on what you provided, it does make a lot of sense, but I think it's more tied to what your offset operators are doing as opposed to technical support for 150-foot setbacks.
Thank you.
Thank you, Commissioner Benton. Other commissioner comments or questions?
Mr. Chair.
Please, Commissioner Hawkins.
When I was looking at this, I had some of the same concerns, I guess, that Commissioner Benton has voiced. Because what I saw was a lot of back calculation into what's the frac length, and then some reinforced, depending on how far apart the stages of the fracs are placed, pretty much dictates what your Joshi radius is going to look like. And I don't know how that's going to really necessarily be enforced at the toe of the well. I mean, there's no next stage to kind of give you a boundary condition. So I agree that there's still some technical questions in my mind of how this would work and whether it would be something that should be expanded. But I think if you have, in this case, 2 spacing units where you're at least proposing or planning that the offset operator is going to do the same thing, that it's going to be a good way to prevent stranded reserves. So I think as Commissioner Benton has said, it's if this was the type of cooperation that you had over a larger area, it would be very beneficial to try to reduce waste. So I think it's a good idea in this case for sure.
I think we understand those concerns and excuse me. I think we understand those concerns and I think that does make sense. And I think that is a critical factor, as you pointed out.
Thank you.
Thank you, Commissioner Hawkins. Other questions? Director.
Thank you, Mr. Chairman. So Commissioner Benton's earlier question and Commissioner Hawkins' comments lead me to need to ask whether do we need to have a condition of approval here that leads to the frac sand and liquids volume? I mean, I'm not sure I fully understand all that's going on here, but what I hear is a potential that the fracs, particularly at the toe and heel, extend larger than what's been modeled.
So a comment is that, sorry if I have to get down into the weeds here a bit, but there's a lot of assumptions that when the horizontal well path is laid out such that, I always forget whether it's supposed to be perpendicular, parallel to principal stress. When you frac them, you're going to get these nice little radial fans that go away from the fracker, they may go up or down or anything. So notionally, most of your energy is directed perpendicular to the wellbore. So when you get out to the toe, you're not going to get much drainage because you're going to have to rely on pretty much what the reservoir will give you. And so I'm not really concerned about the pounds of sand per foot pumped other than how it was used to determine the average drainage radius, and which leads me to a concern that if other operators bring this to you before us again and use the same basic analogies, there shouldn't be any assumption that it's automatically going to get approved just because this one did. And that's where my worry is that folks say, okay, here's the technical basis for what we need to promote. I think each one may have to be based on what's brought forward for the presentation and probably a little bit more technical rigor around some of the next ones. I think what will happen is if the operator chooses to increase the pounds of sand per foot, then perhaps they have too many wells laid out, but then that's their issue and their overcapitalization, which we don't get into the financial aspects of developing this. From a technical standpoint, I think we're probably all right. If you double your pounds of sand per foot, it's unlikely that you're going to extend across the way. And again, it goes back to what Commissioner Hawkins said too, is if the offset operator is going to drill in there, then they're going to have essentially competitive drainage, and it's not going to be that big of an issue if you do get some extension. That may not answer you, but I would not see as a condition of approval a certain frac completion other than an expectation that Great Western would use completion techniques that tie back to what they planned, what they have used and what they intend to use, so that they're not going to go in and double or triple their sand volumes or liquid volumes. And I don't know if that needs to be put in the order or not. Given a choice, I'd ask to have that put in there, I guess.
Commissioner excuse me.
No, I'm through.
You would ask that be included.
Yeah, that they would use completion techniques that were consistent with what was used to establish the Joshi radius and the drainage areas.
Thank you, Commissioner Hawkins.
Again, I think this kind of comes down to if your offset development plan and offset operator agree with your approach and can use a reciprocal approach, then I think that makes good sense. I think if the offset operator were to object and say, I don't like the way this looks. They're going to drain my resource. There could be some issues. So I think that's, in this case, I think it makes sense because there's parties on both sides of that section line that have compatible ideas on development.
Mr. Chairman, if I may.
Commissioner Pierce.
I've participated in some earlier cases today and have demonstrated to all listening that I'm not one of the technical experts. So I will continue that if I may. It seems to me that the matter presented to us in all likelihood reduces waste, and in view of the concurrence of offsetting operators, it does not, in their opinion, damage correlative rights. And therefore, I think this application is in the best interests of oil and gas production in the state of Colorado.
Thank you, Commissioner Pierce. Commissioner Benton.
I agree with that. I would just caution us not to let this become the standard by which we choose to approve these in the future.
Mr. Chairman, if I may, I certainly am not agreeing to reduce the standard setbacks in any field, but because of my support for this application.
Understood. Director.
Thank you, Mr. Chairman. Appreciate all of the comments. I think that staff has a concern about our ability to effectively regulate, monitor, oversee the frac job down to the level of how many pounds of sand. So that's kind of why I raised the question. I concur with the statements about the concurrence of the offsetting owners, with the caveat that I can envision situations in which there may be a significant lag in the development time from those offsetting sections. From what I know, that's not the case here. And, you know, again, if the offsetting operator wants to consent and they're not worried about it, perhaps we shouldn't be worried about it. So appreciate that. I have concerns about our, putting the pounds per frac sand per stage in order.
In light of what Commissioner Pierce said, I'll withdraw that.
Thank you.
Don't have a motion, so we've just been having some discussion here.
Mr. Chairman, if I may.
Please, Commissioner Pierce.
Approval of the application before us.
Thank you, Commissioner Pierce. Is there a second?
Second.
Commissioner Hawkins, thank you. Discussion? Hearing none, let's call the question. All in favor of the application before us, please say aye.
Aye.
Opposed, nay. Hearing none, the ayes have it, and the application is approved.
Thank you
you
very
all.
much. Thank you.
Ms. Stanzik, thank you for standing by and being prepared.
We appreciate your support.
So I'll just say we've really had clearly a lot of preparation have gone into all the hearings today by both the proponents and the staff. It's always the case, but I wanted to make special mention today. Thank you. Commissioners, do you have it in you for a few more moments to call the next and final agenda item? Director, Ms. Murphy, we have docket number 161200550. It's an enforcement hearing concerning Petro Hunter Operating Company. And I.
Yes, sir.
I pass out the lunches?
I would welcome any commissioner who's so inclined. The lunches are available. We could, we've done that before. Do we have seconds?
It's okay. Second.
Who do we have representing staff, and who do we have representing the operator?
Chair, it's my understanding that the operator has not participated. And so I believe from staff, we have David Beckstrom and Kyle Davenport.
Good afternoon, commissioners. This is David Beckstrom. If you would give me your leave just a couple minutes until I can get this presentation pulled up.
And good afternoon, commissioners. Kyle Davenport, Assistant Attorney General on behalf of staff.
Thank you, gentlemen. While you're setting up, the operator is not present procedurally. Could you explain to the commission what that means, please? Okay, Mr. Davenport.
Sure, happy to do that. That means that the operator, when we say not appearing, the operator has not appeared at anything in this matter, not at a pre-hearing conference, hasn't filed anything, hasn't objected to anything. And so procedurally, I believe we have an entered pre-hearing order that dictates that the operator may not present exhibits or witnesses. It is in effect a default.
Mr. Chairman, if I may, just for clarification.
Please.
We are satisfied that all notice has been provided to this operator.
Thank you.
Thank you, commissioners. Again,
I'm sorry, just for the record, that was an affirmative, and thank you.
Correct. Yes. All notice has been provided.
Very important question. Thank you, Commissioner Pearson.
May I ask a question?
Of course, Commissioner Jolly, of course.
It's scheduled for 2:15.
Correct.
Is that a consideration? They walk through the door
Yeah, sure.
at 2:15?
I can give a brief rundown. It's not a concern to us, and the reason why is because the operator has not appeared in anything, and we have given the operator multiple notifications of what's going on, notices, continuances to this hearing date. I have been in contact personally with counsel for the parent company of the operator. The parent company of the operator, if you look at your portfolio, is filed for bankruptcy. The operator, that is the operator in this case, is not a party to that bankruptcy. The contacts we have for the operator are the bankruptcy trustee, bankruptcy counsel for the parent. We have also been in contact with a former employee of the operator. The operator does not have any current employees, directors, officers, anything. And we've been given no indication at any point in time since this was initially noticed back in November that they wish to appear, that they have any intent to appear. The former employee of the operator has indicated to us he has no intention of appearing. Neither has the bankruptcy trustee, bankruptcy counsel for the parent, or litigation counsel for the bankruptcy trustee himself.
Okay.
It's an unusual set of facts. It sounds fairly comprehensive in the procedural piece. Also for the record, for those who may be in attendance or listening remotely, as always, the noticed, part of the notice is the agenda, which contains a statement where we suggest that docketed items the times are subject to change, and we reserve the right to call folks at any time. And in fact, we've seen a bit of that today. But Commissioner Jolly's question is very, very well taken. And I would ask that we continue along, Commissioner Jolly, assuming that's
sure. You bet.
Very good. Okay, thank you, gentlemen. Please proceed.
Thank you, commissioners. Again, this is David Beckstrom, Enforcement Officer with the Commission. And I think the discussion that you just had with Assistant Attorney General Kyle Davenport really brings us to the crux of this entire matter, which is that Petro Hunter Operating is a completely defunct operator. In fact, the name itself is a bit of a misnomer. As Mr. Davenport said, there really is no functioning entity here. It exists only in paper. There's not a live person to pick up a phone, to respond to an email. There's no office. There's not even a PO box. So what we're dealing with is an operator who has, for all intents and purposes, disappeared, leaving behind a number of wells and pits and locations in a varying degrees of disrepair and disorder. Staff brings this to you today as a hearing because we are asking that you find that Petro Hunter Operating has engaged in a pattern of violations by our rules that therefore requires a mandatory hearing. As a part of this hearing, we are going to be asking again that you find a pattern of violations, impose a penalty of $313,140, and also approve staff to take those steps necessary for distressed operators like this to go in, close the locations, and clean them up to make them safe for the people of Colorado. With that being said, this is a mandatory hearing by rule. I know that I'm at this point standing between you and your lunch, and the staff's record is complete in the portfolio. So I would like to give you the option of standing on our record, making ourselves available to any questions, with the exception that we do have some proposed language that we would like to change in one of the paragraphs. So I will leave it to the pleasure of the commission as to whether a presentation summarizing the facts of this case is necessary, or if you would like to move without that.
Mr. Chairman, I would just like a clarification of the proposed changes up on the screen now. If you'd walk me through those, please.
My pleasure, Commissioner Pierce. The proposed language change relates to paragraph 7 at Bates page 193 of the proposed order. What it really relates to is where the source of funding would come from in the instant that staff needs to expend emergency response appropriation funding. This language or similar language to this has appeared in prior orders for distressed operators that you have approved. However, as we are seeing more of these, the director and Wendy Schultz in our office have both expressed a desire to make more clear both the source of the funding and the process by which we would expend that and communicate that to you should the need arise.
Thank you.
Thank you, Commissioner Pierce.
I have one.
Mr. Benton.
Fortunately, since you're on paragraph 7, page 193, I had a question about paragraph 6 on the same page.
Of course, Commissioner.
Would you like me to read it?
I have it in front of me, but you are welcome to present your question.
It says, at the director's request, Petro Hunter Operating will assign equipment, saleable product, and appurtenances, and so on and so forth, to the commissioner or a third party. In light of the fact that there are no employees or anything, how do you expect to accomplish them to honor the director's request?
Honestly, Commissioner Benton, this is language that we've put in all of our distressed operator orders as an ability to clear title more easily. We have no expectation that Petro Hunter would be able to comply with this request, just like we have no expectation that they'd be able to pay the penalty imposed by the commission or to come back into compliance at any of their locations, because they are at this point truly defunct.
So in light of that, then are you allowed to just take it? That's my concern, is that there may be some equipment and there may be some oil in the tanks. There may be something of value there that you can recover as part of the plugging. Are you allowed to just go ahead and take title to that and dispose of it?
I would defer that question to either our eminent counsel, Attorney General, Assistant Attorney General Kyle Davenport, or perhaps the director.
There was discussion earlier in regard to this particular issue and distressed operators. The statute does give authority to the commission to take control of equipment and appurtenances, et cetera. There's also a lien right or a property right that the commission has that stands behind all other interest owners pursuant to the statute. What enforcement staff and the AAGs have been doing is, when we're faced with a situation like this where there is a defunct operator that has left property, et cetera, on location, we are in a process right now of notifying everyone that we can everyone that we can locate and notify, both by publishing a notice, by putting a notice in the staff report that Director Lepore called your attention to earlier today, and by, to the extent we can find folks who have addresses, giving them direct notice with the notification via certified mail. If no one appears at that point, then depending on the situation, we have to deal with it on a case-by-case basis. And that may result in things, as Director Laporte discussed, like finding a way to dispose of equipment that's left on site that no one seems to care about or have an interest in, and the operator is completely defunct.
So there is a path forward that you can somehow or another do that without having to somehow do an inordinate amount of time to track down someone. And you can move forward and take care of this.
Well, I think inordinate might be a judgment call on how much we are spending a lot of time and energy in trying to track down every person that we can before property is disposed of or anything like that. And yeah, we're making every effort we can to make sure that any potentially interested party has notification before we move forward.
There's a lot smarter legal brains here than me, or smarter people anyway, regardless. I'm just, as an operator, it just occurs to me that there ought to be a way to expedite this when you know it's a defunct operator, that you can move forward, because it's a lot of time and effort on your part and the staff's part to try to establish ownership before you can move in and take care of the well. So I guess I defer the question to some of the other folks on the commission, as whether or not there's some way to make this go faster.
I think everybody agrees with you in that regard, and I'll defer to Director Laporte if he has something to say now. I know that's part of some of the legislative agenda, and some things that are being proposed is an easier path forward. In the case of this particular operator, there are people in terms of the bankruptcy counsel for the entity, the trustee, that are paying attention to the assets of Petro Hunter operating the subsidiary in this case, and they've shown no interest in wanting to have anything to do with these either. So that's not the case for every distressed operator, but it is the case here as well. That somebody knows that this is going on, that this action is going on, and they've made a decision not to appear here today.
Director, were you going to add anything, Mr. Davenport?
Well,
I
will.
And then Commissioner
briefly.
Jolly, please.
Thank you. Thank you for the questions, Commissioner Benton. You're honing in on what we're grappling with. I'll just say that the AG's office and our enforcement staff has worked hard and spent a lot of time kind of forging that path, which doesn't exist and is unclear in the statute, doing their best to put in place processes that provide notice, that give the commission some protection, et cetera. But in case you didn't hear it, our lien that the statute provides is secondary, junior, so assistant to other liens. So if we go sell product, for example, like our practice has been that we're going to hang on to any revenue from that for some period of time in case another lien holder comes out of the woodwork and says that money is rightfully mine. And that is precisely why we're beginning to talk to the legislature about ways to smooth out this process.
Commissioner Jolly.
Yeah, I'm just trying to get my arms around the whole situation. Is there 33 wells that they have total?
There are 23 facilities, Commissioner. There are 12 wells, 3 pits at 11 different locations, and all of those are in Rio Blanco County.
Is there anything of substantial value here, or are these just all wells and waiting to be P&A'd?
I think there may be 2 answers to that. From our perspective, because we cannot operate those wells, they are at this point on our list to be P&A'd if you approve the order. There is no one knocking down our door asking to buy these wells.
Would, even if you got the, what, 313,000, and earlier in the documents, it was 436,000 was reduced, but you can't get blood out of a turnip anyway. But what is it going to cost to P&A and reclaim these pits, make the landowners back to whole?
Of course, we at this point have done a very cursory evaluation of these locations. We determined sort of the status as we're able to see them on the ground. The actual plugging costs would be a real-time determination. We have some estimates that we could speculate. I would defer to our engineering manager, Stuart Ellsworth, to maybe give you a range of what those costs would be. I think it is fair to say at this point, we won't see a penny of the $313,140. We do have $60,000 of financial assurance that we are asking your permission to foreclose. But I think it is safe to say that that $60,000 will be a small piece of the overall cost of properly plugging these wells and making these locations safe again.
Is there anything to suggest there's criminal activity to be pursued here?
Not from our perspective, Commissioner. What seems to have happened is more or less in line with the downturn of the commodities market. Petro Hunter operating walked away from their locations, shut their doors, and left their locations more or less untouched from the time they did that. We do not suspect there was any criminal activity.
Thank you.
Of course. Thank you, Commissioner Jolly. Mr. Pierce, were you?
Mr. Chairman, if I
Please.
may, in view of the fact that council has assured us that appropriate notice has been given to anybody they could find to give it to, in view of the record which was presented to the commissioners electronically before this hearing, I would move approval of the application with the proviso that all of the items mentioned in the description that are being sought by the staff should be granted.
Second.
Commissioners, I apologize. I would ask, because there is some proposed language from what you had in your hearing packet, I would ask that that language be modified accordingly. And also, because of the continuance of this, the effective dates of the order as proposed should be changed to reflect today's hearing date. But other than that, those would be the only changes staff would request.
Amend my motion to provide for those two things, Mr. Chairman.
Second
Thank
the
you.
amendment.
We have a motion and a second. Any discussion? Yes, Commissioner Hawkins.
I just wanted to voice my concern that this is exactly what we don't want to see happen in Colorado. And I'm wishing there were a way to kind of ensure that it doesn't happen very often or if ever again. I know that it will probably, but it's the kind of activity that we talk about all the time, that somebody's going to just pick up and leave, and here we are stuck with the bill and the mess and the effort. So I wish there was a way that we could keep this from happening in the future.
Thank you, Commissioner Hawkins. I'm sure many share that sentiment. Thank you. Further discussion? Let's call the question. All in favor of the motion on the table, please say aye. Aye. Opposed, nay. The ayes have it. Thank you, gentlemen.
Thank you, commissioners.
Commissioners, I believe that concludes the business on our agenda today. Anything else for the good of the order before we adjourn?
No, maybe a reminder that we'll be meeting in Loveland in March on the 20th and 21st, and you'll be receiving information about hotels and et cetera in the near future.
I was just about to do so, but thank you. We'll see folks then in Loveland on March 20th. The website has the appropriate dates for filings, et cetera. Thank everybody for their time today, and we'll see you in March. We're adjourned.